Original side mentioning.
Lordships, kind leave, my lord, may I mention one
Microphone, please.
one Section 11 application to appear as to be mentioned. My lord, the time to carry out the amendment has expired. According to the department, a formal order is required.
What is the date of the order?
My lord, two amendments were there. Second amendment has been carried out. The first amendment.
What is the date of the
date
order?
of the first amendment order is 22nd September. My lord.
Yes, to be mentioned tomorrow.
TP.
Notice to the other side.
Yes.
May I leave to mention? This is a Section 34 application. My lord, from the same award, both parties have preferred 34. The other side's 34 is appearing as item number 84 in today's list, my lord. I was praying, my lord, if my 34 can be tagged with this, and my lord, both the pleadings are complete. Any day can be fixed post the Christmas vacations for hearing, my lord.
এটা কি লিস্টে আনতে হবে না এমনি করলে হবে? Yes, to be mentioned tomorrow. Notice to the other side.
Lordship, may I have a kind leave to mention? Lordship, this is with respect to AP 831 of 2023. This is appearing as item number 69 of today's list in the commercial division. It is a new motion section 34 application. Lordship, it was filed on 30th November.
What is it that you want?
Lordship, list, the taking off of the matter, it has not been taken up even once.
Yes, you mentioned in January. Yes.
Lordship, then just a kind indulgence. Lordship, in this matter, the respondents in this matter are the petitioners in another petition.
What is it that you want?
Lordship, it can be tagged if it
Yes.
can be tagged.
Mention in January.
I leave to mention our execution application, your lordship. But the it was last taken up on 16th June 2023, my lord, where the judgment letter was directed to file the affidavit of assets. But till date, they have not filed, my lord. And
What is the date of the order? June.
16th June 2023, my lord.
Yes, you can't mention 1 week. Mention in January. I will pass necessary directions.
I
Yes.
have my lord's kind leave to mention item number 48 of my lord's list, my lord, the commercial division. This is the section 34 application relating to the Srirampur bus terminus. We are for the award holder.
Yes.
We have made an application in the matter for withdrawal of the security and deposit of additional cash security, my lord. The last time the matter was taken up was on 6th December. There is a direction from the Honorable Supreme Court for expeditious disposal of the matter, my lord. I was humbly praying if it could be taken up, upgraded subject to my lord's convenience. This it's item number 48 of
Yes,
my lord's.
but in the next 4 days may not be feasible for it to be taken up. তুমি এটা বুধবার দিন দিয়ে দাও একটু উপরে তুলে দাও নোটিস টু দ্য আদার সাইড
My lord, Mr. Banerjee is appearing in the matter. He's not there on Wednesday.
No.
my lord.
then you
Thursday, my lord, if my lord's.
no Friday I will put it in January. Friday. Yes.
My lord, may I have your lordship's kind leave to mention an execution application? My lord, this pertains to that commercial property adjacent to Hotel Lalit. My lord, by now,
I can't understand what.
my lord, this pertains to the execution application relating to the property adjacent to Hotel Lalit. My lord, by an order dated 8th December, in the stay application, your lordship had directed the award debtor to pay the lease rental at monthly charges. My lord, your lordship had also granted us liberty that if no payment is made within 7 days, my lord, we will be allowed to
You're the
mention
award debtor.
My lord, I am the award holder. My lord, no
Yes.
payment has been made subject to that order. And my lord, this was challenged before the Honorable Supreme Court is in SLP as well. My lord, that SLP has also been dismissed and your lordship's order has been affirmed. My lord,
What is the date of the order?
My lord, your lordship's order is 8th December and the SLP was dismissed on 14th December 2023.
No, you're showing me the Supreme Court order, my order.
Yes, my lord, 8th December.
Yes.
My lord, paragraph 14, 15 and 18.
Yes. So what was the direction on them?
My lord, at paragraph 14,
Wait. Yes, so they if they haven't done it, then the award is not stayed. Then what is your worry? You can just go ahead and enforce it.
yes, my lord, if your lordship kindly sees paragraph 18.
Yes.
My lord, your lordship had granted us liberty seeking with liberty to mention the matter. So, my lord, mentioning the matter for urgent listing. My lord.
Yes, tomorrow.
Deeply obliged.
Yes.
My lord, may I have your lordship's kind leave to mention the matter, item number 23 and 24 of your lordship's list. My lord, this is that matter where Mr. Banerjee was arguing against unconditional leave to defend by Mr. Jishnu Shah on the other side. The lordship had last heard it on 7th December and asked it to appear on 13th December. Thereafter, the matter has been appearing. Only the decisions are left for Mr. Banerjee to my lord side before your lordship. If some precedence can be given, because we have a 100 crore award which is outstanding because of this
Yes, Wednesday.
application.
Yes.
Wednesday, my lord, is 20th, my lord. Mr. Banerjee is not here, my lord.
If you're asking for indulgence, then you also
I-
be ready and come. Yes.
I know, my lord.
Yes.
It can be, my lord, Thursday, my lord. Kindly, I beseech
Friday.
your lordship. Friday.
Friday. Yes.
Execution case appearing, my lord, as item number 42 in the monthly list, my lord. Here, my lord, my lord, there was an order of this court by which, my lord, I was supposed to not use the bank account till for a particular amount of money, my lord. The money has now been paid.
Mr. Mukherjee, you have mentioned once. Please wait for the others to have their chance and then you come back. Yes.
My lord's kind leave to mention in section 11 application of 2021, my lord.
Yes.
It was last heard on in April 2023, my lord. I was only, my lord, the affidavits are also complete, my lord. I was only, my lord, praying for listing, my lord, for final hearing, my lord. That
For the next 4 years, in the 4 days.
my lord, any day, my lord, also.
Yes, yes. In the second week of January,
Great.
11 January.
Great.
Yes.
Seeking leave to mention item number 74 in the commercial division list. My lord, it is a review application arising from a section 11 order. My lord, the maintainability point was heard by my lord and was decided in our favor. My lord, the urgency is that the learned arbitrator has directed us to file the statement of defense as a last chance.
Yes, 12 January. Yes,
Great.
any other originals are mentioning?
Lord, may I hand over the mentioning notice, please?
Yes, hand it over. Yes, Mr. Mukherjee. Yes, your original side. Yes.
Lord, may I be permitted to mention a matter? My lord, this is my execution application, my lord, which was filed in 18th of May, my lord, and the award was filed on 9th of January, my lord, for an amount of 78 lakhs and odd, my lord. My lord, the only urgency is that during the arbitral proceedings, the injunction was granted
Yes,
against
give me a date in January, please.
My lord, the only urgency is the interim injunction was granted in respect to the immovable properties of the award debtors, my lord, which got expired in the month of June, my lord. It is
Court's order got expired in the month of June.
June, my lord.
Then why are you mentioning in December? You have waited all this while. If it's expired, it's
It's
expired.
already appearing in the
Sorry,
monthly
no,
list.
no. If it's expired, then you should have taken steps to have it restored or have it extended. What were you doing all this while? Yes, yes, 10 January.
Lordship, may I be permitted to mention a section 9 petition wherein I am an applicant. Lordship, I had sought leave to file my Vakalatnama. Lordship will remember Lordship was pleased to grant the leave. Now, Lordship, the amendment needs to be carried out in the cause title for which I require the leave. Lordship, kindly allow the matters to be mentioned tomorrow. Lordship, I have already put the other side on notice.
When was the last order passed?
Lordship had granted earlier on Thursday, the leave was granted to file the Vakalatnama. This is a change.
Yes, to be mentioned tomorrow.
I'm
Yes.
number.
Speaking for my lord, Steve, not to mention is section 9. Not here affidavits are complete. Not more than 5 crores is outstanding. Not we're in need of some urgent release. Not if this matter could be listed. Not
Yes, in January. Give me a date in January, please.
4th of January. Not.
Yes, 4th. Notice to the other side.
I'm
please.
grateful. Lordship.
May I
Let
be
I'm
permitted
mentioning
to mention, Your Lordship? This is a part heard section 34 arbitration petition, Your Lordship.
Last
was-
heard on?
Huh?
Last heard on?
Last heard on 5th December 2023 when the matter was ordered to be transferred to the commercial division, Your
Mention in
Lordship.
January, please. Yes. Any other original side mentioning? Yes. Yes, Mr. Mukherjee.
My lord, an execution case, my lord. Here, my lord, the awarded sum, my lord. There was a direction by this court, my lord, not to deal with the
Microphone,
awarded sum,
please.
not to deal with the awarded sum with the bank account, my lord,
Yes.
from the bank. My lord, in the meantime, we have made payment of the full sum. My lord, so my lord, there's nothing which is due and payable. Bank is not permitting us to use our bank account because, my lord, of the order of court. Well, if the matter can be to be mentioned, my lord, an order can be passed, my lord.
Yes, to be mentioned Wednesday.
May my lord's kind leave to mention, my lord, AP 338, my lord, lordship had taken up this application on last Friday, my lord, where to file a written notes, my lord. Lord, I could not file within that day, my lord. Lordship will kindly, my lord, accept the written notes of argument, my lord. It's a
Neil.
2-page notes. Great.
Yes, call on the list.
Appellate side mentioning. Lordship, may I be permitted to mention on contempt application, Lordship? There's a direction of
Date of the order?
Lordship, there's a direction of a Lordship order dated 11th of August 2023 to return the money.
Yes, give me a date in January, please.
Sorry,
Give me a date in January.
Friday.
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 Friday. Lordship.
19th. Yes, call on the list, please.
Original side, commercial division matters. Item number 1, all Amin garments.
My lord, I am appearing for the petitioner. The counsel is online.
My lord will kindly bear with me, my lord. Today I'm appearing virtually.
Yes, that's all right. Yes, Mr. Mitra, I changed the date to Monday because you wanted that weekend. That's why.
Yes, my lord. We did
Yes.
not know.
Did that weekend, will it be reflected on your note or no? No. Yes.
It was completed by Thursday, and my lord found that he is not there in the list.
No, I asked my court officer to put it on Monday since you had asked for time.
Now, my lord, only thing is, my lord, I have referred to 2 judgments, my lord.
Microphone, please, Mr. Mitra. Yes.
I have referred to 2 judgments in the note, my lord, which were not cited by me before, my lord, while my lord making my submissions.
Those are basically on the point, my lord.
But have you given Mr.
I
Jain
have,
notice
my
of
lord. I
that?
have sent them, my lord,
My lord, I have received it, my lord.
Yes.
Thursday.
Yes.
Now that is on the point that, my lord, 340 comes, my lord, after the court decides.
Have you
on
annexed it to your note or what have you done?
No, I have referred to and my
Yes,
lord, I have.
give me a copy, please.
May I file my return?
I will come to you. Yes.
My lord, I'm sorry, I could not keep it within 2 pages, my lord.
Yes, that's all right.
If your lordship is pleased to come to, my lord, paragraph 10
Of which one?
of the notes, my lord.
Of the notes. Yes.
My lord, I have referred to the judgment. I can place, my lord, those paragraphs, my lord, if your lordship, my lord, permits me.
Paragraph 10 starts with storied buildings pursuant to an order. That is the page. Paragraph 10 or page 10.
Paragraph 10 of my notes.
Paragraph 10. Yes, divergence of opinion. Yes. (2019).
Yes, 2019, volume 11, Supreme Court cases 575. I have referred to the paragraphs, my lord, if your lordship permits, my lord.
So you tell me which paragraph have you left out?
The facts were required, my lord.
Very well. This is one judgment and where is the
And the
next?
paragraph 11 is the next one. 11 and then 12, my lord.
The Ranchi.
Yes. It went up before Supreme Court. Supreme Court did not, my lord, touch.
And what is the point, Mr. Mitra?
Basically, on the point, my lord, I was trying to ask before you got that if you not into the section 341.
No, the point of the
Lordship is pleased to come to once, my lord, 340, section 340. May I read it out?
Yes.
When upon an application made to it,
In this behalf or otherwise, any court is of opinion that it is expedient in the interest of justice that an inquiry should be made into any offense referred to in such and such. Clause B of subsection 1 of section 195. Referral of the proof into section 195.
Yes.
Yes, 191B. Any offense punishable under any of the following sections of any applicant.
Yes.
Whether there has to be a private hearing before. Whether it can be taken.
my lord, that stage has not yet arrived. Even, my lord, in my notes, your lordship will find this point was first taken by them before the arbitral tribunal. And the arbitral tribunal said that this would be taken into consideration at the time of final hearing. Now, that is my point, my lord. Even before your lordship, my lord, before the court comes to a conclusion that an offense has been committed, my lord, a hearing has to be given. And that is exactly what, my lord, the Supreme Court has said.
Yes. And what is this Jharkhand High Court?
Same.
Same on the same point. Yes. Yes, Mr. Mitra, anything else?
So those are, if your lordship permits, my lord, I can place that judgment.
No, that's all. You have given the paragraph numbers. Yes, Mr. Jain, how do you react to these judgments?
My lord, as far as my lord, the judgment relied on by my learned friend reported in 2019, volume 11, my lord. In my
Yes.
respectful submission, my lord, this is a per incuriam judgment, my lord. For the simple reason, my lord, this judgment does not say as to why this departure is being made, my lord. The law is laid down by Pritish. My lord. Furthermore, my lord, after the recent larger bench judgment of the Honorable Supreme Court decided in State of Punjab versus Jasbir Singh, my lord, now Pritish is the law, my lord, as regards 340 is concerned, my lord. And this is a two-judge bench judgment which my learned friend is relying on. So, my lord, this in any effect, my lord,
No,
in my respectful submission.
1 minute. Does this judgment refer to Pritish at all or not?
Yes, yes.
No, my lord, no, my lord, sorry. If my lord kindly comes to paragraph 50 once, my lord, of this judgment, paragraph 50. It does not refer to Pritish. What it does, I'll tell your lordship. Paragraph 50 at page 593.
Yes.
My lord will see paragraph 50 deals with judgment reported in Amar Singh Naji, which my lord refers to Pritish at the internal paragraph 7. So it does not rely on Pritish, my lord. If lordship sees, it is only the set out portion of Pritish. It does not, my lord, even for a moment say as to why it is making a departure from the law as laid down by Pritish. So, my lord, in any event, my lord, this is a two-judge bench judgment, my lord, and a three-judge bench, my lord, having decided, my lord, as regards the manner in which an initial application under section 340 is to be dealt with, my lord, that is possibly, my lord, in my respectful submission, law of the land. My lord, now coming to the second judgment, my lord, the Jharkhand High Court, if lordship kindly sees, page number 3, my lord, what had happened here? The Honorable Jharkhand High Court had issued notices to the opposite party. My lord, it was in that backdrop, their lordships, my lord, felt that since notice has already been issued, my lord, to the respondents, they'll be given an opportunity, my lord. My lord, and they having traveled to Supreme Court, my lord, in my respectful submission, my lord, does not, my lord, disturb the ratio of the law as laid down in Pritish, my lord. My lord, today, in my respectful submission, my lord, if the Pritish, lordship will kindly permit me, my notes are ready, my lord, I'll just file the notes, written notes. And my lord, because all throughout, my lord will see all the judgments refers that lordship has to come to a prima facie finding that it is expedient in the interest of justice, my lord. Lordship is not, my lord, for a moment, my lord, deciding on the guilt or innocence of the respondents, my lord, in my respectful submission. These are my respectful submission.
Yes. Learned counsel appearing for the respondent has placed two additional decisions on the right of the accused to be heard in a proceedings under section 340, read with section 195 of the CRPC. Stop. Counsel, next, learned counsel appearing for the parties have also handed up their respective short notes. Stop. Next, reserve for judgment.
Grateful, my lord. People of pleasure.
Oh,
Item number 2, Raitani Engineering Works.
I appear for the respondents.
My lord, I am for the petitioner. If your lordship, my lord, recalls, my lord, this is that matter where, my lord, the clauses of the GCC 64 particularly, my lord, came up before your lordship. And your lordship, my lord, informed us that on that very day, your lordship had passed a judgment. My lord, squarely covering, my lord. My lord, my submission is, my lord, that I am squarely covered under that judgment. And in fact, my facts are better because, my lord, for two reasons. Firstly, my lord, in the case of central organization.
Have you, Mr. Drolia, have you considered the judgment?
I have read.
You have.
I have read.
Yes.
So my lord, in my case, my lord, they never appointed arbitrators as per the clause. They instead asked me for a waiver. I expressly said, no, I do not waive. I want a neutral arbitrator. The correspondence is on record.
Yes, show me the pages, please.
Yes, my lord.
Because I can't say that it's covered by so and such judgment, and therefore it's.
I'll show you, lordship. My lord, kindly, my lord, take page 201. Is my lord there?
Yes.
This is, my lord, the railway is writing to me. A modification order passed by railway board with a letter quoted under so and so, so and so. And then they quote, my lord, the concerned provision. And then they say, under this process, competent authority provided a format, annexure 15, for processing appointment of
No,
arbitrator.
are you also under 63 2B, or are you under some other clause?
No, my lord, the same clause. Where, my lord, 3 arbitrators, my lord, would be appointed.
So it's
because
above 50,
the claim
50
is,
lakhs.
yes, it's nearly 4 crores. Conservative estimate made last year. So it's likely to be higher.
Yes.
So, my lord, the mechanism says that 3 arbitrators, the railways will send me a list of which I will shortlist 2 names. And then I would, my lord, tell them the 2 names. Out of those 2 names, they would decide who my nominee will be. And then the general manager would appoint 2 other arbitrators and also decide who the umpire or the 3 will be. It's a complete sham. And your lordship, my lord, has held so. I mean, with much more finesse in the judgment. My lord, kindly, my lord, take page 201. So they, my lord, seek a waiver.
So by this letter, what do they ask you to do? To waive?
To waive under subsection 12(5).
You are once again requested. So when was the earlier request made?
My lord, we first, my lord, had written to them requesting for an arbitrator on the
No,
20.
so it's not.
Page 190, my lord,
Yes.
chronology is this. Page 197 is I raise my claim and request for arbitration. Then they reply at page 201 saying that very well, there is a waiver. We need your waiver. You give your consent under 12(5). And then I again
And
reply
what did you write in 197?
that this is our claim and please, we would like the matter to go to arbitration.
Yes.
And then they say, no, you give a waiver, only then can we appoint arbitrators because your waiver is necessary. So they acknowledge the fact that unless I give my waiver, this can't go ahead because the appointment would otherwise be barred. And then at page 203, my lord, is my last communication where I say, I'm sorry, I'm not desirous of giving any waiver. So if you, and I nominate somebody from the Bar Library Club saying that I would like him to be my nominee, you appoint your arbitrator and the 2 arbitrators can appoint a 3rd arbitrator, or let's go for a single sole arbitrator. That is at page 203.
Yes.
And after this, there was no reply, my lord, and then we filed this petition. And my lord, in central organization, my lord, one more, my lord, in addition to what your lordships have held, my lord, one more distinguishing factor, that there, the petitioner himself, in his section 11, had prayed for a railway officer to be appointed. Not from the options given, but another railway officer.
Yes, show me central organization, please.
Yes, my lords. What a judgment. Copy nahi.
You can find it out and then give it to me. No, not a problem.
My lord, it's there, my lord. This is the judgment.
No, I'm saying you can find out the paragraph and then hand it over to me.
It's there.
Yes.
Your lordship, my lord, will take paragraph 5. The respondent did not send a reply to the above letters of the appellant, but filed arbitration petition so and so before High Court under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator for resolution of differences. In this petition, the respondent suggested the name of one Shri Ashwani Kumar Kapoor, retired member, electrical, from Railway Board, to be appointed as an arbitrator. Here, my lord, I'm saying I don't want anybody from
So respondent is the petitioner who filed the 11(6).
Yes, and in the facts of that case, he prayed for a railway officer to be appointed. So he never waived, my lord, the requirement under 12(5). Here, my lord, I want somebody, my lord, whom your lordship appoints. And at para, my lord, 20, your lordship will see the reasoning. This has been taken into account that he himself prayed for a bureaucrat to be appointed as an arbitrator who worked in the same organization. My lord, para 20, may I place, my lord?
Yes, so the appellant, the railway said that this chap was not, this person was not part of the panel, therefore did not agree.
Yes.
Yes.
And para 20, my lord, the court takes that into account while distinguishing, my lord, the law. circumventing the law. My lord, it is bad law anyway. That's my submission.
No, and
It
what
has
about
been
the
held
other one?
so by another bench, and subsequently, my lord,
What about the Ladakh judgment?
my lord, on the point of the previous judge, my lord, I adopt your lordship's reasoning in your lordship's judgment, my lord. If your lordship lends me the copyright, my lord, that would be my written submission.
Yes, you wait for it to be set aside and then you come to the court. Yes, Mr. Rolia.
My lord, may I answer in one sentence, my lord?
Yes.
Today, my lord, if your lordship appoints an arbitrator, and hypothetically assuming that the railways, my lord, goes to the Supreme Court impugning that order, the Supreme Court will do what it did in the Bangalore metro case, where
that was under Article 142.
Yet, my lord, the appointment was not set aside. There was no finding that the order was wrong.
The reasoning was that we will not wait for the reference because it will be in the interest of parties or whatever that language was.
So my lord, even if your lordship today appoints and there's a hypothetical challenge, the order would be sustained. That's my submission.
And show me the disputes, please.
Yes.
And the pages.
Yes, my lord. Your lordship will, my lord, take page 119.
No, where is the agreement?
Oh, yes.
Page 22.
Yes, my lord, page 22 is the tender contract dated 14th May 2018. My lord, one more thing, if I may point out before taking your lordships to this, is that, my lord, in the 2014 GCC and the 2019 GCC, there is no difference.
So you're on the 2014?
14. The language is, my lord, similar, save and except for the fact that in the 2014 GCC, if the claim was within 25 lakhs, then one arbitrator, otherwise 3. But in the 2019 GCC, that threshold, my lord, was increased to 50 lakhs.
So you're above 25?
I'm 4 crores. Yes.
No. So under the 2014, you would come under the excess of 25 lakhs?
Yes.
So
So
and what is that clause?
Very
well, you go sequentially, please.
Yeah,
Your agreement first.
It's a yes, my lord. So, my lord, page 22 is the contract.
Yes.
And the arbitration clause is clause 25 at page 72, which perhaps, my lord, may not be visible to the number of the clause may not be visible to your lordship owing to the stitching glitch, my lord.
Yes.
Arbitration clause, and it refers to clauses 63 to 64 subclause 7 of the GCC. Now, these clauses, my lord, are from page 184. And your lordship would then, my lord, come to page 186. Page 186, my lord. In cases not covered by the clause 64.3ai, my lord, this clause was the one where the claim would be within 25 lakhs. So since I'm not covered under that, the arbitral tribunal shall consist of a panel of 3 gazetted railway officers, not below JA grade, or 2 railway gazetted officers, not below JA grade, and a retired railway officer, retired not below the rank of so-and-so, as the arbitrators. For this purpose, the railway will send a panel of more than 3 names of gazetted railway officers of 1 or more departments of the railway, which may also include the names of retired railway officers empaneled to work as railway arbitrator to the contractor within 60 days. Then, my lord, kindly take the next paragraph. Contractor will be asked to suggest to general manager at least 2 names out of the panel of appointment as contractor's nominee within 30 days.
Yes, that's fine. So that's more or less similar to the...
Yes. So, and the railway, the general manager is the one whom I'm crossing swords with. I mean, how can he have a role at all?
No, you're crossing swords as in the GM will have the final say.
Yes, the GM will have the final say, but it's the GM who's held up my payments. Ultimately, he's at the helm of affairs.
Yes.
And he's unceremoniously terminated my my contract after I finished the work.
What was the contract for?
I'm sorry, my lord?
What was the contract for?
Yes, my lord. This contract, my lord, was for constructing RCC box columns, my lord, across the Tarkeshwar and Havra line.
Yes.
So I was the contractor who was the L1 in the auction. Sorry, in the tender, and then the tender was awarded to me. And I was engaged. I did the work. When I went for my money, they said we're terminating your contract because you couldn't finish the work in time. And the reasons, for the work not having been finished in time is attributable to the railways, not me. That's
and they terminated when?
the termination, just terminate it. Termination June 2018 and thereafter.
No, but that is important, Mr. Lakmani. That's part of the dispute.
Yes, my lord. The termination, notice is not annexed to the brief. I'll get back on that, my lord. Kindly just give me a minute, my lord. In the meantime, I'll get back on that.
Why have you not annexed it? If it's a dispute, then the termination is not important.
It ought to have been, my lord.
Yes,
but my lord, my payments have not come in. Even if they terminate
yes, what is the date of termination? Yes, Mr. Drolia.
9th July 2021 was the termination.
And what was the ground of termination?
There's no arbitrary, completely arbitrary.
I'm not asking for your comment on it. I'm asking you what is the reason for termination?
Well, that we didn't finish the work in time. That was what was communicated to us. But
so termination is your weak link. What is it?
No,
why are you not ready on the termination point?
No, it's not my weak link at all. My lord, I have finished the work. I want my money. Even if they terminate, well and good. I don't want to work any
How
further.
much is the outstanding claim?
3 crores 97 lakhs as of 2022. And since then, of course, it would have.
Where is the 21 notice?
21 notice, my lord. There are two. One is at page 197, and the subsequent, my lord, final again, another notice at page 203.
Give me the dates, please.
My lord, at 197 is 21st March 2022, and at page 203 is 16th August 2022.
Why did you send two?
Because to the first notice, they said that you give us a waiver. So then we said that no, we are not agreeable to a waiver, and we nominate Mr. So and so.
And they didn't reply to the final term to the final 21 notice.
No, man.
Yes, Mr. Drolia.
Lord, I praise Lord. The section 10.
Microphone, please. Section?
Section 10 of the Arbitration and Conciliation Act
10.
1996.
10 is on that odd and even number.
My lord, that is the odd and even.
Yes.
Here, my lord, now I will place, my lord, my affidavit in opposition filed in the instance.
So why are you placing section 10? It's 3 arbitrators.
Here, 3
Yes.
But here, my lord, if
microphone, please.
The parties are free to determine the number of arbitrators, provided that such number shall not be even number.
That's all right, but it's 3 over here.
And failing the determination referred to in subsection 1, the arbitrator terminal shall consist of sole arbitrator.
Yes.
Here, my lord, in the arbitration clause,
yes.
there is a panel of 3 arbitrators.
Yes.
So here, my lord, now I place, my lord, my affidavit in opposition which I have filed, my lord, a short affidavit in opposition which I have filed in the instant case, my lord.
No, Mr. Drolia, what is your point? Why do you want to place it? There is a dispute. There has to be an arbitrator. The only question which arises is whether the GCC mechanism will be adopted or the court will appoint. That is all. So what do you have to say to that?
Here, my lord, as the lord...
Mr. Drolia, please stand still. I can't hear you. Yes.
My lord, so far, my lord, the unilateral appointment, judgment of the Supreme Court. So that part gone, my lord. Then, my lord, there is the, my lord, the reference to their own employee. That is also gone. But
no,
here,
gone means what?
My lord, here, my lord, it's not insisted for. I don't insist for, my lord, that.
So then you're fine
with
the court appointing.
The appointment of the 3 arbitrators and qualification.
Yes.
That to be considered, my lord. In the
no, so you're fine with the court appointing 1 arbitrator? What is it that you want?
My lord, here in the petition itself, a document, my lord, one letter has been annexed by the petitioner, my lord, that here petitioner has already nominated his, my lord, arbitrator. So, my lord, now that this is the railway has to appoint an arbitrator in terms of the arbitration clause. So, your lordship is direct to railway to appoint its arbitrator. Railway will appoint an arbitrator, my lord, and this...
No, railway will do no such thing. and neither will the court accept the petitioner's nomination. The court will appoint its own arbitrator. You just tell the court whether you want 1 or 3.
Milord, here, Milord, here, Milord, in terms of the arbitration clause, there should be the 3 arbitrators.
3 arbitrators. Very well.
arbitrators,
Then
Milord.
the court will appoint 3 arbitrators.
And Milord, since Milord, since if the
Mr. Drolia, if you keep moving, I can't hear you. Use your microphone, please.
Milord, if the arbitration clause which is mentioned in the GCC is not given effect, Milord, then Milord, the subsection 3 is in operation. Milord. Section 11, subsection 3 of the Arbitration Constitution Act is in operation of subsection 3 of the section 11. Milord. Failing any agreement referred to in subsection 2 in an arbitration with 3 arbitrators, Mr. Drolia to the court of the 3 and Congress is now on slide and 6. With an application number 6, petitioner has already nominated Milord. Not on the arbitrators of an arbitrator. Milord, we had Milord, what is suggested? Milord, here Milord, was the court's plan. You want 3 or 1? Milord, as per the arbitration clause, there is a provision for the appointment of the arbitrator. Yes, the dispute between the parties are neither now amendment to the agreement dated 14th May 2018, by which the petitioner was engaged as a successful contractor for doing construction work in the
Tarakeshwar hyphen Howrah line of the Eastern Railway.
No, may I have your
Eastern
lordship's
Railway.
leave? May I have your lordship's leave, please?
Yes, no. Eastern Railway. Stop. The dispute is with regard to the petitioner's unpaid bills, which as of 21st, as of March and August 2022, amounted to about approximately rupees 3.97 crores. Stop. The petitioner claims much more as of today. Stop. Next, you can leave, Mr. Lakmani.
I'm
Yes.
so grateful.
Ki bola? Stop. Stop. The petitioner, next, the petitioner further, the petitioner's complaint also relates to a notice of termination dated 9th July 2021, whereby the respondent railway terminated the contract on account of delay. Stop. The petitioner says that the delay was caused by reason of the inaction on the part of the railway. Stop. Capital R hobe short. Railway. Stop. Next, learned counsel appearing for the respondent railway is not opposed to the court appointing an arbitrator to adjudicate on the dispute, but seeks, but insists that the railway should be given a choice in the matter. Stop. Next, beside the judgments, beside the numerous judgments of the Supreme Court on unilateral appointments from TRF v. Energo to Perkins, and the judgments by the high courts on similar lines, the court is not agreeable. The court is not inclined to accept the submission on behalf of the respondent. Stop. the arbitration clause in the agreement is governed by the General Conditions of Contract 2014 and clause 64.3, theta within brackets small a, within brackets small I, would be the governing clause in the present case. Stop. The said clause covers cases in excess of rupees 25 lakhs and under clause II, small ii, comma, the railway is to send a panel of more than 3 names of retired railway retired railway officers to work as the arbitrator. Stop. The contractor will then be asked to suggest 2 names out of the 3 and send and the final choice will be on the general manager, capitals, of the railway. Stop. Each of these steps is time bound and the parties but there is no dispute that the GM of Eastern Railway will choose the petitioner's nominee arbitrator. Stop. Give me a copy of my judgment, please. Next, this point came for consideration. Now, this point was considered by the court in MS Mehrotra Buildcon versus Southeastern Railway, AP 736 of 2023, where a similar clause contained in GCC 2019, was it 2019?
2014. 2019.
GCC 2019 was held to be contrary to the decisions of the Supreme Court. Stop. In the present case, comma, the petitioners, the railway owes, the railway allegedly owes outstanding amounts to the petitioner, comma, hence the GM of the Eastern Railway having the final say in the choice of arbitrators is directly contrary to section 12 within brackets 5 of the 1996 Act, read with the 5th and 7th schedules thereto. Stop. It is significant that the respondent railways letter it is significant that the petitioner refused to waive the applicability of section 12 within brackets 5 of the Act by its letter dated 12th May 2022, by its letter dated 16th August 2022, despite the railway repeatedly asking for such by its letters, asking for such, including by a letter dated 12th May 2022. Stop. Next, there are also substantial factual differences from the Supreme Court decision in Central Organization versus ECI SPIC SMO 2020-14 SCC 712. Stop. In the facts of that case, comma, the respondent before the Supreme Court, within brackets, petitioner who had filed the Section 11 application, close brackets, had not responded to the railway's letters and had also agreed on a person who happened to be an officer of the railways. Stop. These facts are the facts before this court contain no such act of waiver on the part of the petitioner. Stop. There are at least two decisions of the Supreme Court, including in Tatia Constructions and Bangalore Metro Rail Corporation, whereby the Supreme Court has referred to central organization being referred to a larger bench. Stop. Next, in any event, comma, the respondent before the court in the present case is not averse to having the court appoint an arbitral panel. Stop. Next, AP number 784 of 2022 is accordingly allowed and disposed of by appointing. You want three arbitrators?
One submission, my lord. Here, my lord, in my affidavit in opposition, I have already said the petitioner did not complete the work as per the construction agreement dated.
Mr. Rolia, don't you understand? This is a dispute which the arbitrator has to decide. I'm just asking you, one arbitrator or three arbitrators?
So therefore, this allegation I am disputing. Lord, that can be recorded, my lord. I am disputing the allegations that.
Can't you understand the court's question? Do you want one arbitrator or three arbitrators?
Three.
Yes, ki bola? Appointing blank and blank as two of the arbitrators and blank as a presiding arbitrator. Stop. The three learned arbitrators shall form the arbitral tribunal subject to their THEIR, their communicating subject to the learned arbitrators communicating their THEIR, their consent in the prescribed format within 3 weeks from today. Stop. The petitioner shall write to the tribunal with the relevant particulars of the matter. Stop. Next.
Item number 3, United Spirits Limited.
May it please. This is the application under Section 11. The agreement is dated 8th of May 2017.
Mr. Ghosh, 1 minute. Eighth May 2017.
8th of May 17 at page 21 to 31. The Section 21 notice.
Tell me what the agreement is about.
Yeah,
I will have to
I'll
say
just
it in
give
my
you
order.
these two dates. That's
yes.
Right. The Section 21 notice is 19th December 2019 at
Yes.
page 33 and 37.
There are two notices.
No, one notice.
Then you're saying 33 and 37?
33 to 37.
Yes.
Now, United Spirits, my lord, the petitioner had a tie-up agreement with the respondent in the state of Bihar to manufacture liquor, my lord. Thereafter, this was an agreement of 2011. Oh, I'm sorry, 2014. This agreement, in 2016, a notification was passed prohibiting alcohol in that state.
Yes.
So thereafter, my lord, the petitioner had advanced several crores, about 26 crores, in advance to be paid as taxes, etc., in the state of Bihar to the respondent. So the claim is that after it became frustrated because of the notification, the parties entered into a termination agreement, which is dated 8th of May 2017. So this is the termination agreement by which we were supposed to pay some rentals to them and they were supposed to get the refund from the government and give it to us.
So the 26 crores you have paid to the respondent?
Yes, we used to pay advance payments and they had to pay so up to the date of that prohibition, which suddenly came in 2016.
Yes.
They are bound to get the refund and give it to me. Now that's the dispute. But in the reply to the notice, they say that this agreement was forged and fabricated, this termination agreement. They deny it.
No, reply to the notice means your 21 notice.
Yes, to my 21 notice. That is at 14th of January 2020 at page 37 to 40.
That's their reply?
That's their reply. 37. Yes, that should be 36. The earlier letter ends at 36. This is 37. Their letter is at 37. So they say there's no privity of contract, there's no arbitration clause. The agreement, my lord, we have annexed, if my lord comes to page 31, that is where it is signed.
Page 31.
No, I'm sorry, not 31. Page let me, so 29. Page 29 is the arbitration clause. Page 29 of the petition. Just to mark that out. This is the arbitration clause that it will be referred to arbitration.
So page 29, which clause?
Clause F. I'm sorry, clause F. The second. Then my lord will see if my lord turns over the page 30, it is signed by both the parties. Now they first took the point that it is a false and fabricated agreement. Then, my lord, they have filed a supplementary affidavit where they have annexed the Section 9 application made by this petition. Now, there's the complication began there. We filed a Section 9 application, annexing a same agreement which was not sealed. Only the signature was there. Their seal was not there. Thereafter,
their seal means the petitioner's seal.
Company seal of the respondent.
Of the respondent.
Then we withdrew that Section 9 because it was a mistake. We had put the wrong agreement, and we filed again with the.
So how many agreements do you have?
Only one termination agreement, but when it was being prepared, I've explained that. So we withdrew that. We were allowed to.
No, you said we put the wrong agreement. That's
in the Section 9.
Yes.
Once it was pointed out to them by them, we withdrew that. That didn't have the petitioner's signature also. That was the draft agreement. Thereafter, we withdrew it and we have filed a Section 9. So my learned friends have filed a supplementary in this Section 11, disclosing both our Section 9. We admit that there were the two different, just to show that there were.
So what happened to the Section 9 after you filed?
That is also pending. That is also pending. And there, in reply to the supplementary, I've explained what occurred, why this first one was not signed by us, and how it was later signed by them and sent. Now, as far as the existence.
Affidavits are complete in this matter. It's not a new matter in that sense.
No, affidavits are complete.
Yes.
It was heard before and then it will be completed. So, what we want to demonstrate first is they are saying this is a false and fabricated agreement. Your Lordship will see the page 21 where the agreement begins. Page 21, your Lordship will see this is the title of the agreement is Termination Agreement.
Yes.
So this termination agreement is entered into on 8th day of May 2017 between United Spirits and Salson Liquors.
Yes.
And then if my lord comes to page 22 in the middle, after coming into force of the Bihar Prohibition and Excise Act of 16, the petitioner, the parties have not carried out transactions envisaged in the tie-up agreement and usership agreement. So the 2000
Where are you reading from?
page 22.
22.
I'm sorry, right in the middle.
Yes.
The preamble, as it were. They say that we had entered into an agreement in 2014 that they are admitting. Then it's in this agreement, they say that because of these prohibitions, the parties are now desirous of formally terminating the tie-up and usership agreement and wish to resolve certain pending matters.
Yes.
So now, just to counter the point that after this, the next document we have shown is our letter of section 21, and their reply is at page 37, where they say this is a false and fabricated, forged and fabricated document.
Where have they said that?
At page 38. It begins at 37. They've received this letter invoking arbitration in terms of a purported termination agreement. At the outset, it is stated there is no privity of contract. The alleged document purported to be executed on such and such is forged and fabricated. And they deny the claim for 26 crores, etc. that we had made. Now, if my lord comes to page 112, after this termination agreement had been entered into in 17, several correspondence between the parties, and they have referred to this agreement. Page 112.
Correspondence between the parties for what?
Regarding the implementation of the termination. So they had to get back the money, give
So
it
that
to
is
us.
before you send the 21.
Yes, yes. Between the 21, between 2017 and 2019.
Yes.
Immediately after this termination is entered into, first letter, if I may draw your attention, page 112.
Yes.
So they are writing to the Deputy Commissioner. Dear sir, this is to notify your good self that we had, no dates are given, it says had an agreement with USL for producing and selling USL's products in the state of Bihar. The said agreement has come to an end on 5th April 2016. That is the date of the notification, or when the act came into force. Then in relation to the production, we have paid advance sales tax for the financial year. So they admit here that they have paid that tax.
No, so what they are not admitting is the the termination.
Later. So I'm just bringing it one after the other. So
Yes.
this was their first letter. From here, I can only say they had an agreement. They don't mention. So under that agreement, they had paid the taxes and there's no production. So they want a refund. Now, this money, when they are, one of our allegations is they've got part of the refund and they have not given it back to us. So this is just to show what was their stand. So they admit that they had an agreement and it was terminated. Then, my lord, if the next letter, if my lord comes to page 117.
Yes.
So the agreement was entered into on 8th May. This is an email of 15th May.
Yes.
Please send, it should be sent. Please send this is from them to us. Then please send the first installment as per agreement, Salson Liquors with USL. So this was just after the agreement was entered into, and this is a circumstantial evidence that they were asking for installments after that, as per the new agreement. Then, my lord, will come to page 119. This is important.
Yes.
Well, the 119, the first email is from us to them. If I'm reading from top to bottom, my lord comes to the last, the email at the end of the page. May 30th, 2017 at 11:59.
Yes.
So that is written by us to them, and we are saying subject obligations to be completed under the agreement. Then dear Binodji.
So this Binodji is there.
Is their person.
Yes.
And then we say that the following points to be completed for payment agreed due to Salson. 1, 2, 3, the details are given. If my lord comes to the last line, Salson has to finish documentation as per page 11 of the agreement. Table is below, and then the table is set out at page 120. Now, if my lord compares that to the table in my agreement, which is at page 31. Page 31 is a part of the termination agreement. So the parties had no doubt that they were referring to the termination agreement. So this ploy they've taken later. Of course, there was some confusion with the signatures. I'll come to that. So this letter clinches it that the parties are talking about, even on 30th of May, about this agreement. This. Your Lordship will see at the bottom, unfortunately the stamp is there. If my Lord turns over to page 30, bottom right-hand corner, page 10 of 11, and this is page 11 of 11. Page 31 is the page 11 that is being spoken of.
Yes.
So these are two examples, and then there is further letters. Page 121, they refer to an agreement.
Yes.
Which one? Page 120. Yes. Now, page 121, this is written to them. Your payment is on hold as you have not submitted the letter dated such and such. Would advise
You are writing to them.
Yes, would advise you to submit documents as agreed in the agreement. We assure you we will release payment after receipt of these documents. And then they are writing 16th August, the day, that was our reply. I should have read it upwards. 16th August, as per discussion, we have submitted letter to BCCBL and the tax department, sales tax department with full support, but you have still not cleared our rental expenses as per agreement with you.
So they are telling you?
They asked me that we were supposed to pay them some rental.
Yes.
Pending things were left. So we reply that you haven't finished the documentation under the agreement. So these are in August. So these are just some of the letters, my lord, which show that the parties have acted on this agreement. Now this confusion, I have to, then my lord, the page 32, your lordship will see.
Confusion with regard to the signature?
No, signature, yes, I'm coming to that. So page 32 is the first.
Yes.
They had forwarded us this board resolution, which is their board resolution, page 32.
For the termination agreement?
Yes, to enter. They are such and such Sanjay Kumar and Upendra Kumar are authorized to signatory of termination agreement with USL, with any of them as authorized by the board today. So this is dated 1st of May 2017. And on 8th of May, the agreement was entered into.
Yes.
Now this explanation to this, the after much confusion, the reply to the supplementary. My lord comes to the reply to the supplementary. We have explained why the wrong agreement was annexed to the section 9.
Reply to supplementary.
This, second September 2022.
Not here, Mr. Ghosh.
One more. May I hand over a copy? We have got served them.
Yes.
22nd, 2nd of September 2022. Should have been there.
This is your reply or their
This is our reply. It's in the order dated 10th of April. Yeah, it's recorded that it's taken on record. Petitioner. Then, so my lord will see from paragraph 4.
Yes.
Paragraph 4, page 3. So this is the gist of their affidavit. By way of the supplementary affidavit, it appears the respondent is alleging that it never executed any agreement dated 8th of May 2017 and is purporting to rely on the following documents. Then A is the first application under section 9, Well, admittedly, we withdrew that. And the B is the second application filed by the petitioner under Section 9. And is claiming that the petitioner has filed two different copies of termination agreement, which are neither properly signed or properly stamped. Then at the outset, I submit that the contentions made are irrelevant, unnecessary, and misconceived. The petitioner has explained the manner in which the agreement dated 8th of May was entered into and executed. In paragraph 10 and 11.
Yes, it's here.
So there, your lordship will mark the page, paragraph 4 I was placing. This is the dispute they have raised in their supplement.
Yes.
Why did you produce two documents? Then paragraph 5, we have said we have given a detailed explanation in paras 10 and 11 of our petition. I'll come back and place that. I'll finish placing this. Then we had said the first Section 9 application had been filed by inadvertently annexing the copy of the agreement which did not contain the seal of the respondent and which had not been signed by the petitioner. And as such, the same was withdrawn with liberty to file afresh by disclosing the original. Then paragraph 7. By an order dated 30th October, pursuant to the leave, the second application, that's 130 of 19, was filed annexing the correct agreement. And thereafter, we have filed this Section 11 with the correct copy. So now for clarity's sake, paragraph 10, for the sake of clarity, the petitioner reiterates the chronology. Well, here we have given a quick summary of the case. So 2016, this Prohibition Act came into force. Then there was negotiations. If I may read from B, my lord, after much...
So, Mr. Ghosh, all this is to counter their possible argument that there is no arbitration agreement at all. Yes.
Well, so what we said was that paragraph B at page 5 of that affidavit. After much negotiation, the parties had arrived at an agreement as to the terms and conditions to be prescribed in the proposed termination agreement. The petitioner prepared the draft and by electronic mail on 8th April forwarded the same to the respondent. A printout of the electronic mail, including its attachment, was sent by the petitioner to the respondent, which is annexed. Obviously, this draft was not signed by any of the parties. So this is the first draft we sent them by email and by hard copy. Then on 8th May, the respondent's concerned officer, one Vinod Kumar, visited the petitioner's office in Bengaluru and to discuss and finalize and sign the agreement. The agreement was finalized. However, Mr. Vinod Kumar had no authority to sign. One of this agreement, so at this up to this stage, there was one agreement which was signed only by Sanjay. This is the one we inadvertently annexed to the first Section 9. Then, my lord, the story goes on that after getting that, it did not bear the seal of the respondent. Then I've explained here by inadvertence, the copy of this document was annexed to the first Section 9. Then E, upon receipt of the original termination agreement as signed, the petitioner requested the respondent to provide the copy of the board resolution. This is not disputed. They sent us the board resolution, which was of 1st May. And Sanjay Kumar was authorized to sign it. Then G, it was pertinent to mention that the board resolution sent by the respondent refers to termination agreement and authorized Sanjay Kumar to do so, to execute the agreement. Then paragraph H. The agreement sent by the respondent did not bear the seal of the respondent company on the last 2 pages. The legal advisors of the petitioner insisted that such seal be put. As such, upon the request of the petitioner, the respondent again sent a copy of the agreement, this time duly sealed and signed on the last 2 pages. This sealed and signed agreement was signed by the representative of the petitioner. And this is the copy given with this application and with the second Section 9 application.
Very well. That is all, Mr.
And they have never disputed this, that they were authorized to do so. And also they have acted in terms of this agreement. So it is an agreement that is existing.
Acted how?
By all those correspondence where they refer to, they're asking for rentals that's due to them. They had to give the documentation as per the schedule.
Yes, Mr. Bhattacharya. Mr. Dotto, sorry.
My
Yes.
lord, with regard to the communications and others,
Microphone, please.
we do not dispute that there was an agreement to the effect that we would be signing a termination agreement.
Yes.
It was in talks that we would be signing an agreement, but the documents annexed are not the termination agreement, and no termination agreement was signed by the parties. This is my one and only defense. My lord, the mails which have been referred probably are wrongly interpreted because the mail at page 119, if your lordship may.
119.
Yes.
Yes.
Your
Yes.
lordship got it. The last one towards the bottom, it is not my mail, it is their mail. My lord, Vinodji is my person. So they are referring to the documents which they want us to include or execute. It is not our document. So we do not accept the agreement. My lord, where the only document which we say or refer to some sort of agreement is at page 121. My lord, this 121 towards the bottom, the second mail is sent by us, Salson Liquors. My lord, as per discussion with you, we have submitted these letters with full support transfer stock, but you still have to clear rental expenses as per agreement with you. We never say that this is with regard to the termination agreement, but we all along are saying that this is with regard to the 2011 agreement, which was there till notification by the Bihar government. Under the agreement of 2011, we were supposed to do something, they were supposed to do certain things. They were supposed to pay rentals, we were supposed to pay government taxes. My lord, the concept was they would be sending us the liquor, we would bottle it, package it, and send it to the government. Government would pay to us, we would pay to them in return. My lord, this was from 2011 till 2014 when the notification came in. 2016 when the notification came in. And now I would invite your lordship kindly to look to the agreements referred. My lord, first at page 21, annexed to this petition. Starts at page 21. The relevant signature is at page 30. 30.
Yes.
This is the only document where they say that we have signed and sealed by the director. My lord, the other pages right from page 21 till 30 all contains two signatures, purportedly either of both the parties. All the pages, but not sealed or signed or not sealed by any of the companies. A signature without a seal on behalf of the company, probably in my humble submission, cannot be admissible. Only the last page can be if it is proved beyond doubt that it is our signature. My lord, may kindly now refer to volume 1 of our supplementary affidavit. Volume 1, volume 2, volume 4.
Mr. Ghosh and Mr. Dotto, I'm not inclined to take up this matter or devote too much time to it because
A supplementary affidavit of the petitioner. Stop. Next.
No, supplementary by them and a reply by us.
Including a supplementary affidavit of the respondent and a reply thereto by the petitioner. Stop. Next. The main dispute, according to the parties, at the present stage, according to the parties, is whether there is is to the existence of an arbitration agreement. Stop. The arbitration agreement is contained in a termination agreement of 8th May, dated 8th May 2017. Stop. The respondent says, through learned counsel, that the respondent did not enter into any such agreement with the petitioner. Stop. Next, list this matter. On 8th January 2024, for counsel appearing for the respondent to resume his arguments.
Item number 4 with 5, Public Health Engineering Department, GTA Darjeeling.
I'm for the respondent, madam. I'm for the applicant, Your Lordship, in this matter. Lordship, I have come up against the ex parte order.
Ex parte order?
Yes, Your Lordship. Ex parte order of the MSME, Your Lordship. On the last
It's a
occasion,
34. It's a 34.
32 and 34.
36. You want stay of, I can't hear you. Microphone, please. You want stay of the award?
No, I don't want stay also, Your Lordship, because this is ex parte order, Your Lordship. Ex parte order, I don't know, Your Lordship. Now, Your Lordship, on the last occasion.
What do you mean? What is this application under?
Barred by section 19, madam. They have not deposited.
75% you have to
Yes,
give.
my lord, they have not deposited.
75% of the Lordship, we are ready to pay the 75% of the actual amount which is due, Your Lordship. The total work was of 24
No,
crores.
that is not the law. The law is 75% of the awarded amount. What is the awarded amount?
My lord, may I indulge?
Lordship.
On the last date, my lord had.
Don't get so impatient, please. I will come to you. Yes.
Total work was of 24 crores, Your Lordship.
What is the awarded amount?
Now, Your Lordship, awarded amount actually which is payable to them is 42 lakhs something, Your Lordship.
Show me the awarded amount.
Yes,
which page?
Lordship will kindly come to page 15.
15?
15 of section 36 application, Lordship.
Yes. Principal amount is 42.
Yes, Your Lordship. Principal amount is 42. Last but 2. 42 lakhs 36,863.
Yes, so 75%.
We have paid, Lordship, we have paid around, Lordship, 98%, 98.2%, Lordship. Lordship will kindly come to page 40.
After the award?
No, Lordship, before the award only, Lordship.
Can't you understand? Please read section 19 of the MSME Act. Then why are you saying before the award?
Lordship, the difficulty is this, Your Lordship. They have asked on the last occasion, Lordship, they have given one letter asking for 17 crores of this thing, Lordship, as interest. Lordship will kindly see that, which is an impossible amount.
Yes, what is 75% of this amount? How much does it come
Lordship,
to?
the 75% of this amount will come to, I think, 12 crores, Your Lordship. 12, 7.
You have to have the amount calculation ready. What is 75% of this amount?
17 crores.
Why have you not done the calculation and come? Come back after 10 minutes, please, both of you. Yes, what do you have to say?
My lord, on the last date when the matter was taken up, my lord, there was a point of jurisdiction that was raised, my lord, that was to be decided first.
You're saying that Calcutta High Court is not the court?
Lord, after the lordship had told me to go through the judgment passed by the Delhi High Court, my lord, I've gone through the judgment, the Facilitation Council being in Kolkata. My lord, if my lord directs, we'll surrender.
I can't understand what you're saying. Does the Calcutta High Court, according to you, have jurisdiction or not?
My lord, as per the Delhi High Court judgment, where the Facilitation Council has passed the award, that court has jurisdiction, my lord, and that is the Calcutta, my lord.
Very well. So why are you saying 1919? I thought your point is on 75%.
Yes, my lord. 75% they have not deposited of the
What is
awarded
75% of the awarded amount?
amount. It is around 13.5 crores, my lord.
What around? There has to be a figure.
My lord,
Because the award is not a round sum.
No, my lord. It's 17. My lord, it's an interest. Every day it is increasing.
Yes, none of the council, none of the learned council, neither of the learned council are ready.
My lord, I've given the calculation sheet.
Stop this matter tomorrow. Come back with the calculation.
Item
You
number
want to come back tomorrow or after 10 minutes?
10 minutes, my lord. I have
10
to
minutes,
the way
very well.
to
Kera dao to? After 10 minutes. 10 minutes.
Item number 6, Bharat Coking Coal.
Is your leadership, I'm for the petitioner. On the last occasion, your leadership, there was a direction in the order dated 20th of November on the petitioner to communicate the order to the respondents.
You are appearing for the respondents?
I am on behalf of the respondent, BCL. Hey, I am a contractor.
You are
I
the
want to hold that.
respondents?
Yeah, here I am respondent, Lord.
Yes, it's what, under 9 or 34? What is it?
Your Lordship, this is my application under section 34.
34. Yes.
Your Ladyship, prior to that, there's a GA application which is pending under section 36.
For stay of the award?
That is correct. I am ready to secure the amount, your Ladyship.
Yes.
That
So what is the awarded amount? Show me, please.
Ladyship, the award is at page 33 of my of my main application.
33?
Yes. At page 33, the amount is at page 46, your Ladyship. It is 43,000. It is 43 lakhs 21,980.
Page 33 of?
Page 33 of my main application. That is in the AP 482 of 2022.
Main application ki nahi. It's only the GA which has come in the list. Main application ta ashene kano list.
In that event, your Ladyship kindly takes page 29 of the GA.
Yes. Why are you saying it's not there? The GA must be having the award.
It is 43 lakhs 21,980.
Along with interest.
That is correct, your Ladyship.
So how much will that come to?
I apologize, your Ladyship. I have not done that calculation. Kindly grants me some minutes. I shall just come back. With
Yes, learned counsel opening for the petitioner / award debtor is not ready with the calculation, which is required for considering stay of the impugned award, dated 8th November 2021. Stop list this matter tomorrow.
Very well, your Ladyship.
Lordship, only prayer is that the prima facie case is not made out so far as section 36(2) is concerned, Lord. If the subsection 3 is you've seen, the point is to be noted that whether the making of the award was induced or...
Are you? He's willing to secure the amount. What is all this? He is willing to secure the amount. Then why are you saying all these things?
Sir, Lord, tomorrow it will be difficult. I'm coming down from Dhanbad later after in the month of January.
Tell me when you want to come back.
By 8 January.
8 January? Come back after 10 minutes. What do you do? You just come to the court for a holiday? It's a holiday. Just a pleasure trip for you. Don't get ready in matters. What is this?
Well, just received the brief.
Next time I'm going to impose costs.
I understand, your Ladyship.
Next.
Item number 7 with 8, Ashok Kumar Chaudhary.
But I'm for the respondent in this matter.
I appear for the petitioner, my lord.
But I had raised the point of maintainability in this application, my lord, in terms of the...
This is a 36.
But the 36, that the section 34 is beyond the period of limitation. And on the last occasion, I had, my lord, argued on the provisions of deemed service. And I had placed a judgment of this honorable court in Ashok Kumar versus Magma Fincorp. But the respondent was to...
It's an MSME award?
No. Ex parte award passed by the arbitrator appointed by the respondent.
Yes,
Which
so
is
you're saying that
previously,
34 is beyond time?
But the 34 is beyond time, my lord. On the last occasion, I had demonstrated. My lord, this is that matter, my lord, if your lordship recalls, my lord, at 4 instances, my lord, the petitioner's address is the same, where they have received notice.
Yes.
But there was a criminal complaint, a consumer case, and an insurance policy.
Yes.
On last occasion, my lord, what they had shown is receipts of India Post receipts, no tracking report, no.
Very well.
My lord,
Mr. Korkar, have you finished your submissions?
I had finished my submission.
You're finished.
But in
Very
case
well.
if they submit today, I will want to reply.
Yes, yes, Mr. Shahu.
That they had relied on 2 receipts, dispatched receipts of India Post, to say that it was addressed to the petitioners, and on that basis, my lord, it was argued by my learned friend, that it was deemed to have been served. My lord, and I had, my lord, undertaken, Lordship will kindly find that in the last order, my lord, I had undertaken to write a letter or email to the postal authorities to find out the status, my lord.
Yes.
My lord, I had done that. My advocate on record had done that, my lord. And my lord, by an email, may I hand over a copy of the correspondence, my lord? My lord, firstly, my lord, Lordship will kindly take page 2, the email of 8 December, at the middle of the page, my lord.
8 December, yes.
That the postal authorities, my lord, reverted back saying that consignment details not found. Kindly provide the booking details and name of booking post office and other relevant details. But I had provided that, my lord, by way of the next email. And, my lord, lastly, by an letter of 11th of December, my lord, it was informed by the postal authorities that it was time barred.
What is time barred?
My lord, since they say, my lord, the preservation period of the relevant record is over.
Very well. So they can't help
They
you.
cannot confirm.
Very well. Yes.
Now, my lord, secondly, my lord, Lordship will kindly also take, my lord, page 86 once
86?
of the application, my lord.
Yes.
But I'm referring to section 36(2) application, my lord. Lord, this is a letter, my lord, of June, 20th June 2023, my lord. Upon having found out of this award from the execution application, my lord, I wrote to the arbitrator.
What is the date of this letter?
My lord, 20th of June 2023.
Yes.
And I have a copy, my lord. Lordship will kindly take paragraph 2.
Yes.
My lord, may I please it, my lord? With reference to the above referred matter, serial number 1, my client has received the proceeding initiated by Kotak Mahindra Bank Limited before the Honorable Bombay High Court for execution of ex parte award dated 30th December 2017, passed by the Honorable, but passed by your honor in ARB 288 2017 between
So,
Magma.
Mr. 1 minute, sorry. Mr. Shodkar, you've also taken a point of jurisdiction.
Not on the point.
Why have you gone to Bombay High Court for executing the award?
Because the property of the petitioner is situated in Bombay.
Yes. Yes.
There is an ex parte award passed by your honor.
No, let me read it, please. What is your point? Just tell me.
Lordship will kindly take page now, paragraph 3. My lord has specifically stated that I have never received this award, and I specifically request the arbitrator to at least serve me at the award so that I can at least take a point, take appropriate steps. And my lord, that envelope, my lord, was returned, refused. Lordship will kindly take page 91.
So this is your lawyer in the Bombay High Court writing to the respondent?
Yes.
With reference to the execution of the respondent?
Yes. On the point that they have not
Very well.
received.
Yes, yes. So your next point? Yes.
Lordship will kindly take page 91. It was also copy marked to the respondents. The respondents have received it. That is at page 89.
Yes.
However, the letter that was sent to the arbitrator, that was refused. That is at page 91. Receiver refused, that is on 24th of June 2023. On this basis, my lord, may I only, Lordship, my lord, place section 3 once, my lord, for my benefit, my lord.
Of the Arbitration Act?
Yes, my lord.
That's against you, isn't it?
My lord, I'll try to demonstrate it is not. It is not only limited to dispatch. This my learned friend had referred, my lord.
Yes. Yes.
May I please, my lord? Unless otherwise agreed by the parties, A, a written communication is deemed to have been received if it is delivered to the addressee personally or at his place of business, habitual residence, or mailing address, and B, if none of the places referred to in clause A can be found after making a reasonable inquiry, a written communication is deemed to have been received
if it is sent to the addressee's last known place of business, habitual residence, or mailing address by registered letter or by any other means which provides a record of the attempt to deliver it. This is because in my humble submission, a mere receipt knowing dispatch is not sufficient. It is enough manner which provides a record.
Record. No, Millard. That would be all. And Millard, there is nothing which could even remotely be deemed to be Millard, could be assumed to be served on the respondent, on the petitioner, the one.
And the General Clauses Act, Section 26 or
27.
27. That's against you.
No, Millard, that is Millard,
That is
in
also
my
in your
humble
favor.
submission. In my humble submission, Millard, since this section 3 specifically provides the mode of delivery and Millard, the manner in which it has to be served, Millard, perhaps Millard,
Very
due
well.
to a
Yes, yes,
specific
Mr.
provision,
Sharkar, your
Millard,
your quick response to this Section 3, please.
Not the notice that has been, my lord, the burden of proof is on me, my lord, when I'm arguing the point of deemed service. And on 4 places I have shown that the respondent's address is the same, was there. The letter which was there addressed to the respondents during the arbitrary proceedings was conducted, my lord. In fact, the notice also, which my learned friend just
Very well. Understood. You do something, please.
But will
both of
also, my lord, kindly permit me to, my lord, place one point, my lord.
Yes.
Section 31, subclause 5. The
Delivery.
Delivery also means, my lord, constructive delivery. But in terms of deemed service, my lord, I have two
Signed
judgments.
copy of the award has to be
Signed
delivered.
copy. It can be constructive delivery, my lord. That is the purpose, my lord, of introducing the deeming fiction, my lord. And I have 2 decisions, my lord. Two of Delhi High Court, my lord, the Honorable Delhi High Court, to support this proposition. My lord,
That is constructive service.
constructive service. My lord, kindly permit me to, my lord, place those judgments.
Yes. But don't you have all those Teco Trichi and those things against you? Those judgments?
But in this judgment, my lord, Teco Trichi has been considered.
Teco Trichi has been considered.
But this is SRS Entertainment versus Home Stores Limited.
Yes.
Well, we'll kindly takes up paragraph 7. In my view, the word delivered and received cannot be interpreted in a pedantic fashion, that is, of requiring or insisting upon actual delivery of the award to the parties. The practical view of existing realities and practices has to be taken in this regard. The arbitral tribunal has no machinery of ensuring the actual delivery of the award to the parties. The parties, by avoiding delivery receipt of the award, cannot be permitted to hold in abeyance the enforcement thereof against himself, itself.
Yes,
The
yes,
award.
let me read it. Yes.
Paragraph 7 and 8.
Yes, next one.
The next is the division bench judgment, 2018 SCC online. But this is
Justice Banerjee's.
This is Hima Kohli and Rekha Paliman.
Yes. Refers to Teco Trichi.
It does not refers to Teco Trichi, my lord, but my lord discusses on the point of actual delivery, my lord, which was the decision passed in Teco Trichi. But we'll kindly consider paragraph 21. Much emphasis has been laid by the learned counsel for the appellants on the word use of a signed copy shall be delivered to each of the parties. In section
Yes. That's fine. Paragraph 22 refers to that. Yes.
My lord, my submission is, my lord, the purpose of deeming fiction, my lord, is to ensure, my lord, if I was in a position to, my lord, demonstrate, my lord, actual delivery, my lord, I would not have taken the argument of deemed delivery. The provision of, my lord, deemed delivery, my lord, gives me the benefit of doubt to demonstrate before your lordships, my lord, the purpose of deeming
Understood.
fiction.
Both of you do something. Please, tomorrow, you give your 1 page. All right? 1 page, but not so much on the decisions. I will read that. Your points and documents to show delivery and no delivery.
But may I only indicate one thing, my lord? Paragraph 1 of this judgment, the SRS, my lord, it was refused by the addressee. That was the
Very
occasion.
well.
in
Say that in your
I will-
one
I
page.
will- Great.
Refer to the documents. That's the more important part.
Yes.
Yes, learned counsel appearing for the petitioner and the respondent, who are now on the who have made their respective submissions on the issue of whether the award, the impugned award, was delivered to the petitioner / award debtor or not, comma, will indicate their short points tomorrow. Stop. List this matter tomorrow. Next. Yes, call on the first 10 minutes.
Item number 4 with 5, public health engineering.
Yes, what is the calculation?
My lord, the awarded amount is 17 crores 74,089.
Have you shared it with your learned friend?
And the 75% would come to 13 crores 31 lakh 16,818.
13, 31, 16, 818.
818.
13, 31, 16, 818.
That is the figure, Your Lordship.
Microphone, please.
That is the figure, Your Lordship.
75%.
That is the figure which is coming, Your Lordship.
Yes, where do I get the award? Which page?
Award is page 14, Your Lordship.
The petitioner has challenged an award passed by the Facilitation Council on
13th of
13th June 2023. Is that the date? The award does not have a date. Where is the date?
This is the forwarding letter, my lord.
13 June 2023. Stop. The petitioner, the petitioner seeks stay of the impugned award. Stop. Next. The petitioner, as the buyer, is hence under the obligation contained in section 1919 of the MSMED Act 2006. 2006.
2006.
2006. Stop. Next, the awarded amount is rupees 42,36,863. Page 15 page of it. Stop. The award specifies that this amount consists of the principal as well as the interest. Stop. Next, 75% of this figure would be rupees 13,31,16,818. Is that the correct award? The correct amount?
Principal amount is wrongly stated, my lord. The 42 lakhs is only the principal amount, while the awarded amount is 17, my lord. I had given to my lord.
Awarded amount is?
17 crores.
Where are you getting that from?
My lord, with the interest that is to be calculated by the petitioner on the clause point number 4, my lord. Delayed interest on delayed payments to be calculated and given to the petitioner. We had given to the.
No, where does the award say that at page 15? It says the amount comprises of the principal amount and the interest accrued.
My lord, kindly takes the last page of the award at page 8 of the award, my lord.
Page?
8 of the award, the ordering portion, my lord.
Yes.
The third point, buyer unit is liable to pay total principal amount outstanding, that is 42 lakhs 36,000 plus interest thereof.
Very well. What is the interest?
My lord, with interest, it is the interest alone. It is 17 crores 32 lakhs 52,227. So the total awarded amount is 17 lakhs 17 crores 74 lakhs 89,090.
74? 74?
17 crores 74 lakhs 89,000 and 090.
090.
Yes, ma'am.
And 75% would be?
14 crores. My 13 crores I had given 13.
That is the amount.
Yes, what do you have to say, Mr. Subba? Mr. Subba?
Yes, Your Lordship.
Yes, what do you have
Lordship,
to say?
this was an ex parte award, Your Lordship. In fact, and I do not know, Lordship. This is a heavy amount public money, Your Lordship.
Something in Darjeeling?
Yes, Your Lordship.
What in Darjeeling?
Lordship, this was regarding to purchase of a
Yes,
pipes, Lordship.
We have supplied GI pipes.
Water pipes, Your Lordship. We had appeared also, Lordship, but they didn't hear us on that date. And
Mr. Subba, point number 4 in the award, which I missed. Quite specific, doesn't say all this chartered accountant business. Specific interest, how it is to be calculated.
Yes, Lordship.
You have to pay. So 75% would be 13, 31, 16, 818. Yes, ki bolam last time? No. The impugned award makes it clear that the interest on this amount, if this amount was 42, যেটা বলেছিলাম, on this amount will be calculated on each pending bill, and the mechanism has also been clearly specified in the said award. Stop. The principal amount plus the accrued interest would hence come to rupees 17,74,89,090, 75% of which would be rupees 13,31,16,818. Stop. Is that the amount, the final amount? Stop. Next, the award, the petitioner/award debtor will hence secure the amount of rupees 13,31,16,818. 50%, how do you want to secure it?
Bank guarantee, Lordship. By way of bank guarantee.
75% by way of a bank guarantee and 25% by way of a cash deposit within a period of?
Within a period of 3 weeks, Lordship.
3 weeks. 3 weeks from today. Stop. The bank guarantee as well as the cash deposit will both be furnished to the registrar original side of this court within the time directed. Stop. Next. The award will remain stayed. 3 weeks will take us to when? 8 January. The award will remain stayed from 9th January 2024 in the if on the petitioner complying with the directions. Stop. If the petitioner fails to do so, comma, the award holder will be free to enforce the award on and from 9 January 2024. Yes. AP 776 of 2023 is disposed of in terms of the above. What about the 34, Mr. Subba?
Yes, Lordship.
34?
34, Lordship. I'm challenging the award.
No, when do you want it?
Lordship, in the month of January, thereafter only, Lordship. Second week, third week, Lordship.
Yes, list the section 34 application on 22nd January 2024.
Very
Grateful. Yes, the next 10 minutes Passover matter.
Item number 6, Bharat Coking Coal. আপনার নামটা?
I have the calculation, my junior.
Yes, give the calculation, please. Mr. Ghosh, I can't hear you.
Sir, I'm very sorry, I'm handing up this paper, Millard.
Yes.
Sir, because I did not get when I did it immediately. Millard, the awarded sum, if a lordship takes Millard, page 29, Millard, the awarded sum is Millard 43,21,980,
yes,
which will calculate an interest of, which I have given the calculation, 15% per annum from the date of the award, which I don't pay. So award is 8th of November 2021. So Millard, I have given the calculation 15%.
Have you shared it with your learned friend?
I'll share it.
Why have you not done it, Mr. Ghosh?
I am here, but I have a copy here, and I think I'm sharing. 43, Yes, my lord, the awarded.
What have you done in this? You have shown me the multiplication and the division.
No,
What is the
actual
amount?
Actual amount, my lord, is, my lord, for 2 years is 56 lakhs 18,574.
Very well.
And if
Yes,
lordship
please
wants to
share
add,
it with your learned friend.
I have shared it. For 2 years, if lordship wants to, my lord, add the 1 month extra, my lord, it will come up, my lord. The next figure I give, my lord, it's 56 lakhs 72,598.
Yes, naturally, till December.
Yes.
Very well. This is an application for stay of an award dated 8th November 2021. Stop. By the impugned award, comma. The petitioner, within brackets, respondent in the arbitration, was to pay, was held to be liable for payment. No, was to pay rupees 43,21,980,
yes,
along with interest at 15% per annum on the awarded sum till date of actual payment. Stop. Next, the calculation made over by on behalf of the petitioner / award debtor shows that the awarded amount should now would now amount to rupees 56,72,598.75 till 31st December?
Yes. Till
Till-
December.
Till December or 31st December?
31st December.
Till 31st December, stop. According to learned counsel opinion for the petitioner, comma, this amount would be, the calculated amount is till TILL, till 31st December 2023. Stop. Next, the petitioner will hence secure
Any round figure, lordship gives me.
an amount of rupees. So it's coming to about 57 lakhs.
7 lakhs. roughly.
57 lakhs, 57 lakhs, comma 50% by of which shall be secured by way of a bank guarantee and 50% by way of a cash deposit within 3 weeks from today. Stop, both of which are to be furnished / deposited with the registrar original side. Stop. Next, the award shall remain stayed on and from 9 January 2024.
But can it be 4 weeks, my lordship? If your lordship so commences.
No,
I don't
3
want.
weeks. I've given a much higher amount for 3 weeks in the last matter. The award will remain, the impugned award will remain stayed on and from 9 January 2024. If the petitioner complies with these directions, stop. If the petitioner does not, comma, the award holder will be at liberty to enforce the award. Stop.
And let the matter appear anything.
GA1 of 2023 is disposed of in terms of the above. 34 is running in the list.
34 is not running in the list.
Mention the matter. Next. Yes. The registrar will invest the amount in an interest bearing account with a reputed bank. Next.
Item number 7 with 8, Ashok Kumar Chaudhary.
তোমার কি গন্ডগোল হয়েছে?
9. Item number 9 with 10, Deepak Bhargav.
Yes, my lord. An order was passed on 6 December 2023. Please look at the order, my lord.
Yes, that last installment.
Yes, my lord. The first part of the order, it says modification of an order. The initial order, that is pre section 34, was 13th September 2023. Now, my lord, your lordship said, my lord, your lordship.
No, the last installment by 15 December.
Yes, which, my lord, we paid in 2 installments on 12th September, 12th December. On 8th December and 12th December. We have complied
No,
with
1 minute, Mr. Bose. Come to the last page of the order, page 4.
the order
Restore-
dated 13th
yes,
September, whereby were
failed to deposit the last tranche of rupees 10.34 by 15 December.
Yes.
So this amount you paid when?
Yeah, my lord, we paid 2 tranches, one on 8th by a demand draft of 8th December 2023, and the other by a demand draft, my lord, of 12th December 23, and both the demand drafts were handed over to the registrar on 12th.
Very well. So this entire 103482 that is now paid.
Yes, it has been complied with. Now I will be praying, my lord. So the earlier application under section 9.
So 13 September order is what order?
That initial my lord, info.
Show me the order, please.
Yes. That
13
my lord,
September article?
yes. My lord, may I hand over a copy? I mean, instead it's
Yes,
there
yes,
in my
yes,
annex.
yes.
It's easier. My lord, this should be, in fact, disposed of or whatever, because we have paid the entire.
No, what was the stricture on you?
Man, the stricture was not to operate any bank account or
That's at
combined
page
bank.
4.
Yes, combined bank account without.
Show me the page. Page 4.
Page 5, my lord.
Page 5.
Yes. Your lordship already modified it by saying that you will be able to, for the purpose of making payment, you will be entitled to operate. But the amount as such is specified there, which now, my lord, nothing.
So you will not. So the direction was that you will not operate without keeping this amount separate.
That was yes. Yeah.
So now you want to operate all the bank accounts, but not what happens to this amount?
That has been deposited.
That has been
I have so everything has done.
Yes.
Now, my lord, your lordship will dismiss this section 9.
Yes.
And my lord, there are these 34. The question, because your lordship's order records that I will consider stay of the award only after I comply with the entire deposit.
The order says some restoration of something, 13th.
No, my lord, yeah, that is one aspect of the matter. The other aspect, my lord, your lordship says.
So the page 4 of the last order says we'll consider restoring, appropriately restoring.
Yes, that is different, my lord. The other, my lord, in the 20th November 2023 order, your lordship had noted that I will consider stay of the award when the entire money is deposited. My lord, 20th November, page 3 of the order. And I also said, my lord, that don't give directions now, because have your lordship found the 20th November?
Yes.
Yes. Now, my lord, I will be praying 2 things, or rather 3.
Just says that the court will consider issue of modification of the order.
No, my lord, that is the
Page 3 of 20th November.
No, my lord, modification. The question of stay, the page 3 last part, top, right at the top, page 3.
Yes.
The question of stay will be entirety. Now, my lord, I'll be humbly praying you, my lord, the stay of the award in my section 36, which I have filed, and my lord, dismissal of the section 9 application, because that's a enforcement award, and 2 other things. My lord, both of us have filed an application for setting aside.
Yes.
I have said 20 days delay. They have said 30 days delay. According to me, my lord, there is one line of judgment saying because he had gone for a section correction, section 33, there is no delay. According to me, the judgment, Supreme Court judgment does not apply, because it's a question of nothing. The award has not been modified. Award is not modified. Delay with it. You escape from the rigors of.
So you want your 34 to remain and theirs to go?
No. Both you can
both
condone.
to go.
No,
both to remain.
both to condone the delay and you can give directions. But according to me, Bellad, although they have not prayed any delay, but in the body of the petition, condonation, they have prayed 30 days delay. And I have prayed for a formal, Bellad, condonation of delay of
No, but section 33 point is there for both of you.
Yes. Both of us filed 33.
No,
Yes, Mr.
33 was filed by them,
Yes.
which was dismissed.
Yes. So they have calculated, my lord, actually, according to me, it should be from the date of the original. If you don't modify the award, you can't escape. This way, my lord, people are now learning about
Yes, yes, yes.
33 and
filing
filing one after the other. My lord, this is so I said, no, you have to pray for condonation. So I prayed, my lord, 20. I said, you include a prayer. So whatever it is, my lord, your lordship will.
So you're saying that you're applying for a 33 will not set the clock back?
My lord, depends on the facts of a case. If the order is modified, then of course, yes.
But if it's not, then.
If it is, my lord, I don't want to, this is not subject matter here, but for abundant caution, I have prayed for this condonation.
And what about yours?
They have said 30 days delay, but not included in a prayer, but you will.
Lordship may kindly condone. It's from the original award. The date has been it has been calculated from the original date of the award, that is 29 June. So we have prayed otherwise that we have said there has been a delay of the 30 days.
But no prayer for condonation.
I'm praying for condonation.
But your lordship will say delay if he is condoned and both.
So what is this? A new line of decision making that if both parties apply for condonation, then the
This
court
is,
should order.
I am an arbitrator in some, and some people are just applying. So, and very important questions arise. Can you charge fees? Well, I'm not, because this is something you don't.
What charge fees? The arbitrator?
For the section 33. Another new hearing is starting.
No, so both of you have gone for correcting of the award.
No, I have gone for
Only you.
correcting, but they also, my lord, your lordship will say delay if any is condoned in both. And
so you don't want me to take a strict view of 34(3) read with the proviso?
my lord, no. If you would take a strict view, there is a Supreme Court, then there is no delay.
Then there is no delay?
No.
33?
33, if you count from the date of the passing of the rejection of 33. Now, question is, my lord, because Supreme Court says otherwise. Supreme Court.
Very well. How much delay is
mine
in
is
your
20,
case?
20, my lord.
And ours is
20.
30.
And theirs is 30. Although there is no prayer, your lordship, from the original award.
And both of you have filed a 34?
Both of us are.
On different issues.
Yes. So your next argument will be what? That the award should be set aside?
My lord, no. Yes. Award then and my money should be refunded.
Yes. What do you have to say to that?
No, my lord, directions, your lordship. Here the 34.
Yes. The last order passed by this court, the last order dated 6 December 2023, records that the court would consider modifying the order dated. Why did I say restored? That 13th September is not against you.
Yes, it is. Because if I do not comply, then
yes.
with my Lord, may I take your leave?
Yes. Ki bola? Modifying the order dated 13 September 2023, whereby the petitioner / award debtor was restrained from operating its individual or collective bank accounts without keeping aside a sum of approximately rupees 26.34 crores. Stop. The said order was made in an application under Section 9 of the 1996 Act by the award holder. Is that correct? Award holder. Stop. Next, learned counsel appearing for the award debtor submits that the amount of rupees 10,34,82,336.25 has been deposited by the award debtor to the registrar original side of this court in 2 tranches on 8th and 12th December 2023. Stop. Next, counsel accordingly, learned counsel appearing for the award debtor accordingly seeks modification of the order dated 13 September 2023. Stop. Next, this order. Next, the order dated 13 September 2023 put a restraint on the award debtor from dealing with its bank accounts without keeping aside a sum of rupees 26,34,82,336.25. Stop. Since this entire amount, since the award debtor has now secured the entire amount by way of demand drafts, all of them are demand drafts, by way of demand drafts furnished on various dates to the registrar original side of this court, the order, the order of 13th, the order dated 13 September 2023 is vacated, stands vacated. Stop. What happens to the AP? Dismissed? Yes. AP 664 of 2023, which was the respondent award holder's application.
Your Lordship, along with my GA for modification.
Is similarly is dismissed for the same reason. Stop. The award holder's application for GA1 is what? Stay.
Your Lordship, for award debtors
Yes, yes, application for modification.
Modification.
Yes, the award debtor's application for modification of this order being GA1 of 2023 is also disposed of. Stop. Next,
Your Lordship, my application under section 36(2), that is
yes,
the item number 9.
the award debtor's application for stay of the impugned award under section 36 within brackets 2 of the Act is also disposed of by stay of the operation of the impugned order, impugned award. Stop. This is in view of the award debtor securing the entire awarded amount as recorded above. As recorded above. Stop. Next, the court is also informed that there is nominal delay on the part of that there is delay on the part of both the is also informed that both the award debtor as well as both the parties before the court in AP, what is 664?
Not 664 is the section 9 which your Lordship just.
No, then what is what am I hearing now?
777 and AP
Yes, AP 784 and
777 and 783.
777 and 783. AP 777 and 783. Sentence. The court is also informed that both the parties in AP 777 and 783 of 2023 have filed for stay, filed for setting aside of the award with delay by reason of the petitioner award debtor in 777.
777.
In AP 777, applying for correction of the order award under section 33 of the 1996 Act. Stop. Learned counsel appearing for the parties, however, say that the delay in view of the proceedings before the learned arbitrator for correction of the award may be condoned. Stop. Next, upon hearing counsel, this court is of the view that upon hearing counsel and the decisions of the Supreme Court and High Courts on the effect of Section 33 of the 1996 Act on the issue of limitation, comma, this court is of the view that the delay may be condoned. Stop. Next. List both the APs. List AP 777 and 783 of 2023 on. Give me a date, please.
Your Lordship, we'll give a direction for affidavits, perhaps.
Yes, the parties shall file their respective affidavits in opposition and reply in both the APs within
3 weeks after the vacation, Your Lordship?
No, no. What 3 weeks after the vacation? 2 weeks after the vacation, reply within
2 weeks thereafter.
reply within a week thereafter. Stop. List both the matters. List both the APs on 29 January 2024.
So let's do one more direction. Since the records will be common, let a common informal paper book may be filed by the concern.
Yes, as long as it's not bound. Yes, the parties shall also be at liberty of filing a common set of informal paper books. Stop. For the convenience of the court. Next.
Item number 13, multiplex equipment.
Lord, this is an application primarily under Section 15 of the Arbitration and Conciliation Act.
Why is it under 29A then?
Alternatively, under Section 29A. Lord, we had to do this, my Lord.
15. So you want to substitute arbitrator?
My Lord, I don't mind.
No, then
I'll tell
why
your Lordship what
29A?
happened. I'll tell your Lordship what happened. My Lord, the first period of 12 months came to an end. We continued with the reference. Both parties participated. Then, my Lord, the further period of 6 months also came to an end. We didn't realize it. We filed our notes of argument 2 months thereafter. Subsequently, my Lord, we realized that that all timelines had gone by. Both parties had participated till filing of notes of argument. When we realized that this was the position, we would have therefore, my Lord, we would be required to file a Section 29A application. But by then, my Lord's judgment had come in that matter, which says that once the time expires, you can't file a Section 29A. So, my Lord, we filed, and special leave petition had also been filed. So, my Lord, we filed an application under Section 15. Alternatively, my Lord, if, my Lord, the judgment is upheld.
No, doesn't 29A6 provide for substitution also?
Yes, it does. No, the difficulty is here the original timeline has come to an end. We are happy to proceed with the main arbitrator, but my Lord, the respondent, my Lord, has raised a Section 16 issue in the arbitration.
With regard to 29A?
With regard to initial appointment of arbitrator, that was referred to final hearing. Section 16 was disposed of, referring the matter to final hearing. So naturally, my Lord, when the 29A or 15 issue now comes up, his, my Lord, main objection is that the arbitrator initially didn't have jurisdiction. So I, my Lord, on second thoughts feel that instead of going into the entire issue of whether the learned arbitrator, her appointment was consented to by the parties, it is better.
No, why don't you want to go 20, because 29A6 also presumes existence of the subsistence of the mandate.
Your Lordship had held that after the time mandate
Yes, yes,
comes
while
to an
extending the period referred to.
Yes. Your Lordship
Open
can,
to
my
the
Lord,
court.
but I can't apply under 29.
Because the mandate has gone.
Yes, the mandate has gone. So therefore 15, and your Lordship.
Show me the last minutes, please.
No, the lead matter is item number 76.
What do you mean by lead matter?
That is the matter. There are 4 matters, not 3 matters. The license agreement, the facilities agreement, etc.
No, no. Show me the last minutes.
It's not. I don't think they have annexed.
Not there.
No, in items. In item 76.
No, page 104. That's not the last minutes. One of the minutes.
Yes, my lord. No, that's my notes of argument, my lord. 10.
Yes, but mentions the name of the arbitrator.
Yes, it does. So, my lord, I'll tell your lordship the controversy about the appointment. My case is that when I requested for appointment of arbitrator, Lord, COVID was very much in place, and my Bombay representative went with a letter to them. They signed on the letter and sent it by post back to me. I have the envelope. My learned friend says that that sign, Lord, that signature is a forgery, and that is
Yes.
the bone of contention. Ultimately, my lord, I have unpaid rent and charges. I don't want to spend a lot of time arguing, my lord, on who should be the arbitrator. So I'm ready to accept, my lord, my learned friend's argument that the
And
arbitrator.
appoint a new arbitrator.
I don't mind, lord.
And what is the 14 is de jure and takes a lot of time and all that. 15 substitute.
Substitute, my lord. The new arbitrator will hear the final
No,
arguments
no,
again.
the ground. I'm asking you the ground.
15, my lord, is termination of mandate and substitution of arbitrator.
No, I know that, but the ground must be there. Like 14 has a ground, gives a ground.
Yes, so here, my
Takes
lord.
an inordinately long time or something is under 14. What about 15?
My lord, the subsection 2 is where the mandate of an arbitrator terminates. A substitute arbitrator shall be appointed according to the rules that were applicable. Now, my lord, here I would submit that termination of proceeding is, my lord, a different concept. So where, my lord, the proceeding is pending and the mandate has been terminated, there, my lord, ipso facto, I'm entitled to an order of appointment. Because here the proceeding is pending. And I've come within a period of 3 years. You know, kindly have a look at section 31. In fact, 32.
That's termination.
Termination. So, my lord, here there has not happened any termination of proceeding. So, the arbitral proceeding is pending. And it's not that we have been, my lord, guilty of any undue delay. Both of us, my lord, participated in the arbitration till August 2023. And thereafter, my lord, we filed this application.
And when did the mandate terminate?
My lord, according to us, my lord, 22nd November 2022, 1 year period expired, and the further period of 6 months, my lord, expired on 22nd May 2023, and 29th of August 2023, my lord, we filed notes. I presume, my lord, my learned friend also filed notes. I'm sorry, my lord, I shouldn't say I presume. The respondent also filed on 28th of August, 1 day before me.
Very well. And so after this, the hearing has been going on.
My lord, hearing stood concluded. We both
in
finished
August
arguments and we filed notes. Then we realized that this is what has happened.
And then there's nothing recorded in a minute.
There's nothing recorded. First 6 months, my lord, I think it was an understanding that the arbitrator would record it, but the learned arbitrator did not. But we proceeded. Then, my lord.
No, I'm saying after, post 29th August 2023, after filing of notes.
No, my lord, there is
nothing happened.
There is nothing. Is she the learned arbitrator?
Yes, what do you have to say, Mr. Das?
Well, I must, my lord, only one indulgence to from my lord. My learned friend is led by Mr. Kamath. He's from Bombay. He had called me up requesting for an adjournment. To agree to he'll make a prayer for adjournment.
Tomorrow.
My lord, the request is, my lord, that there are affidavits which are required to be filed because in item number
I
76,
don't
my lord,
allow affidavits in these matters.
my lord, I will only have to take instructions whether he'll be able to come by tomorrow, my lord.
That's bad luck. Tomorrow, it's the last week before court reopens. I can't make these accommodations anymore. Yes, and this is not a matter, I don't even allow affidavits in a section 11.
The reason being, my lord, the case that has been made out is with regard
But
to 29.
I'm going to appoint an arbitrator. What case will you make out?
My lord,
Are you willing to go on with the earlier arbitrator or
My
have
lord,
a,
we are
then
definitely not
why
willing
do you
to
want to
go on
file
with,
affidavits?
we are definitely not willing to go on with the
Why do
previous.
you want to file affidavits?
My lord,
Answer
the
the
only
question.
reason being, my lord, the entire case that they have made out is in respect of a 29A. The operation of section 15 would not come into effect. And also with regard to whether there is actually jurisdiction to proceed with arbitration because of the issue being under the issue under Easement Act, and it would be operated under the Presidency
No.
Small Causes Court Act.
I'm telling you
My lord,
before.
only to that effect, I want to file the affidavit.
Absolutely not. Tomorrow I'm keeping the matter only because you're saying that there's somebody arguing from outside. That's all. 29A, I'm going to appoint an arbitrator, and 15(2) I think says that parties will have the liberty of continuing from where it left off or something. I will say that.
In case, my lord, that is where I would have indicated that I object to it being started off from that point. Rather, it should
Very well.
go
Let
on
me pass
no,
the order to
no, my lord. My lord, I may come back. My lord, may come back tomorrow.
Tomorrow. Yes, learned counsel appearing for the petitioner has made his arguments on both section 29A as well as section 15 of the 1996 Act. Stop. Next, learned counsel appearing for the respondent seeks an adjournment on the ground of counsel appearing from Bombay, from Mumbai, not being present in court today, not being present in court / or in the online mode today. Stop. Next, list this matter tomorrow.
May it appear with item 75.
Yes, list this matter along with AP.
740? 747 of 2020.
747 of 2023. It is made clear that no further adjournments will be granted, given in the matter. Next.
Vidyut Electricals.
13, 14, 15. But item 13, 14, and 15 are between the same parties. May it stand over tomorrow.
Yes, list this matter tomorrow along with AP Com 11 of 2023. Next. Act order kore dao to. Act order kore. Next. Next.
Item 16, Inderjit Malhotra.
My application under 29A, but I must be candid before your lordship, my lord. I need to, my lord, annex 1 minutes of the learned arbitrator, which we have missed out. My lord, kindly give me leave to file.
No, where's your respondent?
My lord, respondent we have served.
When?
My lord, we have served on, my lord, 12th of December. And my lord, I believe they will have no objection, my lord. They also.
No, your mandate continuing and all that.
No, my lord, paragraph 8, my lord, we have said it is supposed to, has ended on 13th of December. We have filed the application on 11th. On paragraph
So
8.
what do you want to file?
My lord, that the pleadings have been completed, my lord, that those minutes, and where the learned arbitrator himself records that the 6 months period as consent of parties also.
Tomorrow.
Yes.
Learned counsel for the petitioner seeks to file, bring a document on record. Stop. Counsel otherwise says that, otherwise, counsel says that the mandate of the learned tribunal ended on 13th December 2023, and the present application was filed on 11th December 2023. Stop. Next, list this matter tomorrow as prayed for. And Mr. Ghosh, please inform the other side once again.
Item 17, National Insurance Company.
I'm for the petitioner, my lord. My lord.
Microphone, please.
I'm for the petitioner, my lord. May I file my affidavit in
My opposition.
Opposition?
My opposition.
There was a direction for opposition and reply, lordship. So
yes.
Your lordship, the opposition was allowed on payment, subject to payment of costs. I've paid the cost, your lordship.
And reply you're filing today, Mr. Banerjee?
No, yes, lordship. I have served him earlier. I have affirmed him earlier within time.
Very well. The affidavit in opposition as well as the reply are taken on record. Yes, Mr. Banerjee, when do you want to argue your matter? Not this side of the vacation. When?
Convenient to your lordship.
Lordship, may I
Give me a date in January. Yes.
Lordship, may I only indicate last day Mr. Banerjee had
Mr. Banerjee has in fact started and completed, and your lordship there. Very well, your lordship then keeps it any.
What? Started and completed what?
Your lordship, I was under the impression that Mr. Banerjee has completed, but he's saying he'll have some more to say. So your lordship.
Very well, I will. Show me the award, please.
Lordship, volume 2, the award starts, Lordship. Lordship, just a small description of the matter, Lordship.
Very well. When do you want to come back?
Convenient, your lordship. The first week of January.
Yes, learned counsel appearing for the petitioner / award debtor seeks to conclude his submissions on 5th January 4th January 2023. Stop list this matter on that date.
Grateful.
Obliged, Lordship.
Matter number 18, Union of India, General Manager, Southeastern Railway.
Well, in this matter, Mr. Siddhartha Lahiri is appearing on behalf of the Union of India. I'm praying for short Passover, madam.
No Passover. Come back tomorrow. Adjournment is prayed for on behalf of counsel appearing with the petitioner. Stop list this matter tomorrow. Next.
Lordship, this matter is listed pursuant to the directions of.
I can't hear you.
Lordship, this matter was listed pursuant to the direction of Supreme Court.
I can't hear a single word. What are you saying?
Lordship, this matter was listed pursuant to the directions of Supreme Court to dispose of this matter preferably within 6 months. So I
Yes,
was praying if some.
learned counsel appearing for the petitioner / award holder points out that there is an order of the that the Supreme Court has passed an order expediting the hearing of this matter. Stop. Tomorrow. Next.
Matter number 19 with 20, Kesoram Industries Limited.
Violet. Item 19 is my setting aside application, and item 20 is the setting aside application of my learned friend.
Yes. Yes.
My lord, may I briefly tell your lordship? My lord, the dispute which was referred to arbitration, the background on the basis of which the dispute was arbitration. My lord, there was a contract between the parties which was entered into in 2016, not for setting up a manufacturing unit, my lord, of cement, which was required to be funded by the petitioner. My lord, the contract was for setting up 3 units, 1 composite, 3 units, ACs, all cement-based units. The initial mobilization advance was required to be given by the petitioner to the extent of 30 crores, and the total cost of installation and erection of the project was a little in excess of 60 crores. And my lord, the also contract provides the manner in which the 30 crore was required to be adjusted. Now, on the basis of which I give the respondent in my application, the sum of rupees 30 crore. My lord, the factory is set up. My lord, but there were 3 units that were required to be set up by them. What is the DMM, which is the cement ready mix motor plant, and one is the ACC block, which is the auto-cleared aerated content block plant, and the other is the fly ash. So they were unable to set up the first and the basic, which was the DMM plant. Well, the contract also provides that they were required to achieve something called the minimum assured production. In respect of all 3 is already given. So many metric tons per day. It is also mentioned in the contract. Now, on the basis of this, we were required to place orders on them and they were required to supply to us. So, well, the contract was such that they will construct the plant, run the plant, and then manufacture for us. And we will take the entire manufactured finished goods, we will take and we will pay for it. So this was the entire arrangement. That is why we funded the entire project for them. Yes. And we were required to sell it in my brand. So that was the entire idea. So there was initially deficiency quantity, deficiency in the quality of the goods. This was the initial problems. Thereafter, we realized that since the first DMM plant could not be set up by them, successfully commissioned by them, yes, the entire project was incomplete. The contract also provided for something called the commitment charge.
Yes.
It is our contention that commitment charge, that the person who was the respondent here, they would be entitled to commitment charges only once they achieve the minimum assured production. And there's a in the contract, there is a mechanism provided on the basis of which commitment charges will be paid by us. So which provides that once I place an order based on the minimum assured quantity of say 100 by way of an illustration, but the minimum assured quantity once they receive, I place an order for 100, but I do not take 100. I take 60. So I have to pay them for the balance 40. And what do I have to pay? That is prescribed in a schedule to the contract, that this is the manner in which I have to pay for the shortfall. So we say that the contract provides that the minimum assured or the commitment charges is basically the payment that I am required to make only to the extent of the shortfall.
So the arrangement is that they will give you what? They will supply what?
They will manufacture and I supply me these three: ready mix motor,
yes,
fly ash bricks, and ACC bricks.
And the minimum assured amount will be on their delivering or supplying also an agreed amount.
Agreed amount in the contract.
In the contract?
Contract. That
yes,
minimum I would be required, the minimum assured production. Yes. Production, that is the production. They have to achieve that production.
Yes.
So unless that achieve that production, the question of commitment charges would not arise. This is our interpretation of the contract.
Yes.
And this is what we say is this is what the contract provides. Thereafter, they were unable to achieve the minimum production, the assured production. They were unable to achieve. So under these circumstances,
so you are, according to you, therefore your assured payment or whatever term you're using, that also did not arise.
Did not. No, they did not achieve.
Therefore, you also were not required to pay that minimum assured
commitment charges.
Yes.
Because we say that both are interconnected. Unless you achieve the minimum assured production, the question of payment of commitment charges does not arise.
Yes.
Well, at this stage, we propose to terminate the contract, and we terminate the contract. At the termination stage, we were contemplating an exit mechanism. What would be the nature? And the contract provides that upon termination, the sum that I have paid to them by way of mobilization advance to the extent of 30 crores, the contract itself provides that the entire amount will be refunded to us, and they will be able to retain the entire project, the factory, the whatever they have constructed, they will be able to retain it and run it independently. And I will get back my 30 crores by way of refund.
So you terminated and they went to arbitration?
They went to arbitration.
By a court-appointed arbitrator?
Yes.
Yes.
Well, there was a panel
so
of
the Section 221 notices of them,
yes,
of
yes,
theirs.
Yes. We have a counterclaim there. So, well, principally, my lord, led by Mr. Mukherjee. Now, my lord, their claim were towards this commitment charges, they had three claims. Now, they say that in course of the performance of the contract, they had raised invoices. and there were invoices raised by them towards commitment charges. So I have not paid to an extent of the invoice which they raised towards commitment charges. So that was outstanding. There they have a claim. There they have a claim. That was their first claim. Then the second claim that they had was that towards minimum commitment charges, my lord, towards the fixed charges, there's a manner in which commitment charges were required to be computed.
What was the total claim?
My lord, their total claim.
No, just give me a rough figure.
Be a little in excess of 300.
300?
300 crores.
300 crores.
So, my lord,
And your counterclaim was dismissed and you were asked to pay 300 crores or
no,
less?
partly allowed.
Your counterclaim partly
Yes,
allowed.
partly
So that was
allowed.
adjusted to the 300
Yes, that
crores.
was adjusted. That was adjusted. That was adjusted. Yes.
Yes,
Plus-
Mr. Mukherjee. So what is the what did the arbitrators hold?
My lord, really, my lord, there were, my lord, as my lord, my learned junior has indicated to your lordship, my lord, they had, my lord, in substance, three, my lord, major claims. One was, my lord, prior to termination, while the plant was operative, my lord, their case is, my lord, we did not, my lord, order quantities of the end product, which, my lord, they had a capacity, they had achieved the capacity for, and therefore we were liable, my lord, not only to pay the invoiced amount, but also certain commitment charges. They say we have partly paid it, and my lord, there was a balance, my lord, to be paid. My lord, that is one aspect of the claim. The second is, they said, my lord, that the termination, my lord, was illegal. The agreement was, my lord, had a lock-in period of 10 years with an option to mutually agree to an extension of 6 years. Therefore, after this alleged wrongful termination, when, my lord, nothing, my lord, was ordered from them, I was, my lord, liable to pay commitment charges on, my lord, the entirety of, my lord, the capacity amount, my lord, which they claim to, my lord, have, my lord, reached. It is really, my lord, a guaranteed sum. Third, my lord, they had a claim on account of future earnings, and, my lord, another on reputation, etc., and interest. Now, my lord, only two claims of theirs were allowed. That is, my lord, unpaid commitment charges prior to termination, and, my lord, after, my lord, the wrongful termination. Since termination was wrongful, the balance of the period, my lord, for, my lord, 10 years, my lord, there, my lord, commitment charges on, my lord, the achieved, my lord, committed, my lord, capacity. This is what has been allowed. So it's, my lord, roughly, my lord, 127 crores plus, my lord,
So, Mr. Mukherjee, this commitment business is only your liability in terms of you would have to make a committed amount to them, make over a committed amount to them, and that was conditional upon their achieving
Correct,
a
my lord,
target, or that was
no, it's
unconditional?
conditional. So, my lord, our case, my lord, when we challenge, my lord, this part of the award, my lord, is ignoring, my lord, there is, my lord, the award has been passed, my lord, ignoring, my lord, certain, my lord, material provisions, my lord, of the contract. And second, my lord, is, my lord, that it is contrary to the contract. Both ignoring, my lord, certain provisions, as well as, my lord, contrary, my lord, to the contract. My lord, this is, and third, my lord, relying on, my lord, associate, my lord, Supreme Court judgment, my lord, to, my lord, the effect that, my lord, if, my lord, there is, my lord, which is, my lord, it's in the nature of a annual minimum guarantee, or, my lord, liquidated, my lord, formula, my lord, for liquidated damages, my lord, no actual damage having been proved, my lord, Kailashnath, my lord, they could not have got this at all. And fourth, my lord, and
so no pre-estimate also.
Correct. My lord, the pre-estimate is, my lord, the commitment charges.
Yes.
So, my lord, this is, my lord, our, my lord, challenge, my lord, to, my lord, the claim, my lord, to the extent it has been allowed. Now, my lord, in our counter claim, my lord, what has been allowed, my lord, is, my lord, mobilization advance. But, my lord, the refund of mobilization advance, my lord, there is a provision, my lord, in the contract itself, my lord, as to, my lord, refund with, my lord, interest at an agreed rate. My lord, that agreed rate, my lord, has not been given, my lord, up to the date of the award. So, my lord, it is, my lord, in violation, my lord, of 31(7)(a), my lord, of, my lord, the Arbitration and Conciliation Act. Because your lordship's aware, my lord, there are two periods, my lord, prior to award and, my lord, on the award.
Pending deleted.
Correct. And, my lord, that has to be, my lord, as per the agreement. And that has, my lord, not, my lord, been granted.
So, Mr. Mukherjee, when do you want to continue in January?
My lord,
It's a tribunal of 3 members.
yes, my lord, 3.
It's not court appointed, my lord.
Not court appointed.
Not court
Not to my learned seniors correction, my lord. It's
No, it's not court appointed. No, I'm sorry.
we nominated, my lord, each arbitrators and they decided on the presiding arbitrator.
Yes. Give me a date, please, Mr. Mukherjee.
My lord, on, my lord, my lord, my lord, could it be the 3rd, my lord, subject to your lordship?
3rd, yes.
ठीक है, sir.
What is it, Mr. Bandyopadhyay?
No, my lord.
You fell to the bait, actually.
My
Yes.
lord, my lord, I was hoping for a short reply, but anyway, my lord, 3rd January.
My lord, 3rd is fine, or my lord,
It's
whichever.
too close to the reopening. That is what
My
I'm
lord,
saying.
9th, my lord, I don't mind 9th, subject to your lordship. 9th,
Yes.
Lord, 10th of January, my lord, kindly.
Learned counsel appearing for the petitioner / award debtor will continue with his submissions on 10th January 2024. Stop. List this matter on that date. Next. Call on the next matter, please.
No, no, my lord. No, tomorrow I'm told, my lord, the execution is coming. My lord, where your lordship had said, my lord, really, my lord, both matters would be heard together. So I'm told, my lord,
No, I don't think that kind of a.
But I'm sure my
if you
learned
fell
friend-
from in the execution for this amount, which has been awarded to me,
Very well, Mr. Mukherjee, let the execution come. Then we will see.
Very well.
they have an application. I'm sure they'll argue that application.
Yes.
Also keep it
Next. Next.
The execution proceeds. I don't mind.
Item number 21, Devi Enterprises.
But it's my application under section 34, my lord.
Mr. Bandyopadhyay, you give me a date, please, in January when you want to argue it.
My lord,
And who was appearing for the respondent?
my lord, Mr. Utpal Bose. Mr. Utpal Bose was leading the team, my lord.
Very well. Yes.
Around 10th of January, 10th, my lord, 10th of January.
So that none of the matters get taken up. Yes, list this matter on 10 January 2024 as prayed for.
Huh?
Next.
My lord, on the last occasion, your lordship had been pleased to direct us to file the award in a separate volume. My lord, may I submit it today?
Yes, yes. That the award is that thick.
Yes, my lord, there's a dissenting note as well, my lord. So,
Tribunal of three members.
tribunal of
Yes.
3 arbitrators, 2:1.
Yes, yes. A convenience volume prepared by the petitioner containing the award is taken on record. Next.
Grateful.
Item number 22, Food and Public Distribution.
My application under section 34.
34.
Pleading
Mr. Banerjee, give me a date, please.
Come back any day in January. Only one request, my lord. Your lordship had directed the MSME Facilitation Council to produce the records because our cases there was no statement of claim that was filed, and we wanted to take advantage of
And that 75% all that is done?
all that is done. 19 is complied with.
Yes, yes.
Pleadings have been exchanged.
So you're saying that all the documents are they have
Your
brought the
lordship had
documents,
directed them to have the records produced here.
but they haven't done it.
They
or
haven't done it.
haven't
We've
done
written
it.
to them. They haven't done it.
So what do you suggest should be done, Mr. Banerjee?
Another direction.
And you have written to them. When was the last time?
Well, the matter was taken up on September 1st, 2023, and thereafter reply dekhi habe. Thereafter we wrote to them on 18 September, and they've received that on the same day. If your lordship wants, I'll file this by way of a affidavit of
No, no. When is the last time? 13th, you said. 13th September.
September 1st, 2023. The matter was called, 18 September 2023 is when we had called upon them to produce the records in terms of your lordship's order.
So 18 September, you have asked them to?
Yes.
And they haven't done
They
anything
haven't
after
done
that?
it, no.
Yes, learned counsel appearing for the petitioner / award debtor submits that despite asking the facilitation council to produce the records on 18th September 2023, the council has not and that too pursuant to a direction of the court, the council has not responded to the request. Stop. Next. List this matter on, give me a date, please, Mr. Banerjee.
Whenever.
List this matter on 5th January 2024. Stop. The petitioner shall write to the council once again in the meantime.
Well, the affidavit in reply be kept.
Yes, the affidavit in reply is taken on record.
Great. Great.
Non-commercial matter, item number 1, Legal Chandra Roy.
And it's not this.
I want the original motion receipt got misplaced as her and come back
When do you want to come back?
after meditation.
Yes, learned counsel appearing for the petitioner, applicant seeks to come back after service. Stop. Next. Give me a date, please. First week, second week.
Second week.
Place this matter on 8 January 2024 as grateful.
Grateful, my lord.
Item number 2, Asif Latif.
I beg to appear on behalf of the petitioner in this matter. My lord, on the last occasion, we have been asked to give our written notes, my lord. My lord, notes is ready, my lord. Only few judgments are required to be incorporated, my lord. Under 2 days' time, by Wednesday, we will file our.
No, have you not referred to those judgments?
Yes, we have filed those judgments on the last occasion when we were arguing the matter. But those are there are 3 judgments regarding that.
No, have you new judgments or already cited? That's what my question was.
There are certain new judgments. Those are required to be given along with the written.
So will you not give them copies to Mr. Nondi?
No, that is not ready, my lord.
What is not ready?
Those judgments are required to be attached with these written notes. That
Yes,
is not,
learned counsel appearing for the petition.
I am praying for 2 days' time, my lord.
After substantial hearing of the matter, learned counsel, okay, the matter has been heard on several occasions, and by the order dated 5th December 2023, counsel were requested to file their respective notes. Stop. Next, learned counsel appearing for the petitioner seeks to rely on certain new judgments, now seeks to rely on certain new judgments and prays for some more time to prepare the note. Stop. List this matter on 3rd January 2024.
Lord, then I'm not filing my written notes today. In the event there are new judgments, then I have to deal with.
Give it.
Not sure. Yeah,
The notes of the respondent, numbers 1 and 2.
no, Lord, mine is number 2.
Respond numbers 2 and 4 are taken on record. Yes, Mr. Banerjee, what is this? 5th December, you got the direction, and now on 18th, you want to cite some more judgments.
Well, not a question of judgments, Lord, just the ones which I had cited.
Yes.
I cited a Bombay, my lord, which had, my lord, the entire law relating to, my lord, possession not being disturbed.
New judgments or ones already cited?
They were already referred to in that.
So no new judgments?
No new judgments. I will, my lord, take out those relevant paragraphs of the judgments already cited for your lordship's kind consideration for ease of convenience, nothing else. I'm not citing anything anew.
New judgments are Respond number 4 is you, Miss. Yes. So you should have done it all this while. I don't know why you're taking so much time.
And bear with me, my lord, only for this occasion, my lord. On the next day, my lord, I'll not give you a lot.
Yes, next.
Pleasure.
Three, Mrs. Ramgaur Swami.
Respondent, for extension of time mandate of the arbitrator, which is expired on 14th of June.
Mr. Doctor, microphone, please.
Milord, the mandate expired, Milord, on 14th of December 2023, and we filed this application on 12th of December. Milord,
And with or without the 6 months?
no, Milord, this is with the 6 months.
With 6 months.
The 29A4. Milord,
So your 1 year extended, your 1 year expired in June.
Yes, 14 June 2023.
Very well. Yes, first time. First time. And what is the stage of arguments?
My lord, arguments are to commence.
Are to commence.
Commence in the sense, my lord, I initially started, thereafter, my lord, they filed applications for taking again, recording the evidence of the expert. Then the expert had to be called. The expert clarified, my lord. There are at least 4 or 5 interlocutory applications.
Yes, what do you have to say?
I have no objection.
No objection, but I will give limited time. And it's unfair on the arbitrator if you go on filing application. This is an application for extension of the mandate of the learned arbitrator. And the first time that the petitioner has come before the court. And the first time that the applicant has come before the court. Stop. The next learned counsel agreeing with the petitioner. Applicant submits that the mandate expired on 14th December 2023 and the present application was made during subsistence of the mandate. Stop. The mandate takes into account, also takes into account the additional period of 6 months under section 29A within brackets 3 of the 1996 Act. Stop. Next, the court is informed that the parties are yet to commence their arguments. Stop. Next, AP 854 of 2023 is accordingly allowed and disposed of by extending the mandate for 4 months from 14 December 2023.
Affidavit of service may be kept.
Affidavit of service is kept on record.
Deeply obliged.
Item number 4 with 5, Lily India Private Limited.
Well, this was the section 36, my lord. That matter with the comb and the
So Mr. Chaudhary had finished his submissions
my
on
lord,
the
he
last
just had
day.
to, I think, also complete his submission. He just had to complete his submission. He
Yes.
won't take long.
Yes.
But he's on also.
You're on the unconditional stay.
Yes, my lord. Unconditional stay, my lord. On both, my lord, 36 proviso A and B. Second proviso A and B, we come under both, my lord.
Yes.
And and we have this additional point also. The award is a nullity because the award has been passed by a sole arbitrator who was appointed by the others.
That's a 34 point.
And 36 also, my lord, we have judgments which have been passed by this honorable court as also, my lord, division bench of Delhi High Court, where, my lord, it has been held that an award which is a nullity, there, my lord, for a 36 unconditional stay can be granted. Because the award is
Nullity
a
in
nullity.
terms of unilateral appointment.
Unilateral appointment.
Yes, this is different. Yes.
Lord, here also it was unilateral appointment.
Unilateral.
Yes, my lord. From the first day, my lord, we had taken the point that the arbitrator could not be appointed, mostly because there was no arbitration. Not mostly. The reason being the arbitration agreement itself was not existent. And my lord has been appointed by the other side unilaterally.
No, but is there a question of waiver?
My lord, we never submitted to the jurisdiction because our point from day one was that, my lord, that the arbitrator could not have taken cognizance because the arbitration agreement was not in existence. And section 16 we had also filed to that extent. At that point of time, the Perkins judgment wasn't there, my lord. So there was no question of a waiver.
So there's a difference, Mr. Mukherjee, between saying that the arbitrator could not have entered into the reference because there being no arbitration clause and unilateral appointment. There's a difference.
I agree, my lord.
Yes.
All we are saying, my lord, at that point of time, at the relevant point of time, my lord, the Perkins judgments, those were not there.
Yes.
And this was in 2016 when the arbitration had commenced.
Yes.
And my lord,
But
by the time the award
TRF Energo is 2017.
Well, by the time the award came, my lord, the judgments were not there at that point of time. The award, my lord.
Award TRF Energo also.
Award, my lord, is TRF, my lord. I'll tell you, lordship.
It's 2017.
20.
I'm telling you.
Award is 28th July 2018 and TRF was 2017 8 SCC. Well, at the what was the order was there at that point of time, but we had already participated in the arbitration for quite some time at that point of time.
So then that participation was taken as waiver? No.
Well, there was we had never submitted to the jurisdiction of the arbitration tribunal at any
Very
point of time.
Yes.
Well, I'll leave for my senior.
Lord, 10 more minutes. Only to sum up. Lord, on the last occasion, I had already shown your lordship the reason why we have made this application. Lord, under section 36, that proviso. Lord, there are two aspects to the matter.
Yes.
One, that there was no arbitration agreement, and my lord, the corollary of that, the making of the award was induced by fraud, because my lord, the thrice, my lord, it was not decided that whether there is an arbitration agreement or not. Besides the others, my lord, that will be on merits of section 34. I am not troubling your lordship. Now, my lord, for the purpose of section 36, lordship will have to come to a prima facie finding that, my lord, there is no arbitration agreement, which is the basis of the award. Now, for that, my lord, section 7, it has to fall under any of the three limbs of section 7. Now, my lord, the learned arbitrator, while considering the section 16 application, has relied on the judgment of Govind Rabar, which is also before your lordship. Lordship will find that, Lord, with the notes it is there. I am also handing over another copy.
So this is against you?
No, my lord, it is in my favor. My lord, it is in my favor, but the learned arbitrator has, with respect, my lord, has misread the judgment. My lordship will see. But kindly comes to paragraphs 15 and 16. And I am relying on this to show, my lord, that there is no prima facie arbitration agreement.
Yes.
The lordship will find in paragraph 14, section 7 has been quoted, and section 7, my lord, subsections 2, 3 and 4 are relevant. Arbitration agreement may in the form of an arbitration clause in a contract or in the form of a separate agreement. Now over here, the alleged document, it is supposedly as if it's in form of an arbitration clause in a contract. Now, 3 and 4 is saying an arbitration agreement shall be in writing. 4 is saying an arbitration agreement is in writing if it is contained in a document signed by the parties. And parties here is plural. That is, both parties will have to sign. Unilateral signing by one party will not do. And the second alternative is an exchange of letters, telex, telegram, or other means of telecommunication which provide a record of the agreement. We are not concerned with clause C. So it either has to be A, 4A or 4B. A lordship would recall before the arbitrator, thrice this issue was raised. Firstly, on the first sitting, when the arbitrator said that it need not be signed, it can be otherwise than that. That is, my lord, perhaps clause B. Then, my lord, in section 16, the actual email was produced. A preliminary trial was made, and, my lord, it was considered that the email which did not have any signature does not have any attachment, any other attachment. It is a singular page document. There, the learned arbitrator held that it is not possible to believe that transaction worth such a high transaction will be carried out, lakhs of rupees would be carried out on an unsigned document. And at this stage, where averments made in the statement of claim is to be deemed to be true and correct on the basis that it is a plain, we are going. Then, my third, after trial, when it was shown that the letterheads are different, the email ID, the website, all are different, and contemporaneously they did not have that letterhead, all this. Well, the final finding in the award is, I will not go into the issue again, I have already decided it. And at the end of the day, it has been served physically. And Miller, there is a contradiction in the two paragraphs which I had shown your lordship, 20 and 22. One breath, it may not be signed by the parties. On the other breath, it can be otherwise.
Yes.
So, my lord, if I read, if lordship now comes to para 15 and 16,
A perusal of the aforesaid provisions would show that in order to constitute an arbitration agreement, it need not be signed by all the parties. Section 7(3) of the Act provides that the arbitration agreement shall be in writing, which is a mandatory requirement. 7(4) states that arbitration agreement shall be in writing if it is a document signed by all the parties. But a perusal of clauses B and C of 7(4) would show a written document which may not be signed by the parties even, then it can be an arbitration agreement. So, my lord, it is only B and C. We are not concerned here with C. We are only with B. But a perusal of clauses B and C of 7(4) would show a written document which may not be signed by the parties even, then it can be an arbitration agreement. Section 4B provides that an arbitration agreement can be called out from an exchange of letters, telex, telegram, or other means of communication which provide for a record of the agreement. Now, so far as this line is concerned, there is a finding of the learned arbitrator itself that the email doesn't have that, the witness had conceded in cross-examination. On reading the provisions, it can be safely concluded that an arbitration agreement, even though in writing, need not be signed by the parties if the record of the agreement is provided by exchange of letters, telex, telegram, or other means of telecommunication. Here, my lord, that other means is not recording any arbitration agreement, which is the email. Section 7(4)(c) provides that there can be an arbitration agreement in exchange of statement of claim and defense in which existence of the agreement is alleged by the party, not denied by the other. This situation doesn't arise here. If it can be prima facie shown that the parties are at ad idem, then the mere fact of one party not signing the agreement cannot absolve him from liability under the agreement. In the present day of e-commerce, in the case of internet purchases, tele-purchases, ticket booking on internet, and in standard form contract, terms and conditions are agreed upon. In such agreements, if the identity of the parties is established and there is a record of the agreement, it becomes an arbitration agreement if there is an arbitration clause showing ad idem between the parties. But this line perhaps has been misconstrued. Well, it relates only to all e-commerce, not actual. The learned arbitrator holds that there is oral evidence that somebody had come and taken this agreement. If that be so, then there is a signed copy. There will be a signed copy.
So, according to you, in these facts, what ultimately the arbitration clause was physically delivered to your office?
Yes, that is the evidence.
And was never part of any email exchange, etc.
No, according to my evidence, it was never delivered.
Yes,
according to their evidence was somebody had physically come and collected it. Those 7 additional pages, somebody had come and collected it. And it is on record that all this is supposedly happening on the next day after the contract is entered into. And this is also not the case made out in the SOC, the statement of claim, that somebody had come and collected it on the next day. And if there is a physical collection, there will be on record a signature that so and so comes and signs it.
Yes.
The signature which they rely, it's only signed by them. If somebody had gone on my behalf, it has to fall under B. So ultimately they make out a case under clause 7(4)(b), 7(4)(a). But 7(4)(b) was the case made out on the first date, which was demolished. Arbitrator proceeds as if it's a clause under 7(4)(a). And admittedly, even their document doesn't show that there is some signature. I can understand that I'm disputing the signature. Nothing. Nobody has signed on our behalf. So, on the face of it, there is no arbitration agreement. Therefore, we are entitled to unconditional stay. And second, the making of the award, there are 3 aspects to it. I'll quickly summarize. The arbitration was made on the basis of debit notes. That is the statement of claim. Is that there are 4 debit notes. The debit notes were raised because loss was suffered by the claimant, because the foreign buyer had rejected their goods and did not make payment. And foreign buyer, we established before the arbitrator, and all the debit notes, one thing to be noted, they are all post-suit evidence, or rather, post-proceedings evidence, in the sense that the debit notes come into existence after section 21 and the arbitral tribunal is constituted. That is number 1. Number 2, it was established before the arbitrator that they have received all the payments in respect of the contract in question.
Yes.
We had got all the payment details from there. Then, my lord, they are allowed to change their case. Further debit notes were introduced. That case is also disbelieved, and the finding is there. Arbitrator makes out a third case of loss of profit for them, which they have not made out in their statement of claim also. And, my lord, awards 10% of the entire contract value, which has not even been claimed by them. Their statement of claim is, I have suffered 50% loss. Well, that is squarely, that is of course, section 34, one of the ground covered by Justice Nariman's judgment in associated. But here I am only trying to say the making of the award is vitiated for two reasons. Number one, the existence of arbitration agreement not decided. Number two, three facts are there. At every stage when the case of the claimant is failing, somehow or the other, the award reveals the arbitral tribunal has made out a case which is not there in. So both these cases combined, we are entitled to an unconditional stay. And last point, now that the Perkins judgment had come in, Lordship will consider the two judgments, one of our Court of Justice Saraf, I believe Lordship had considered it in other cases. So this is 2023 SCC Online Calcutta 605.
Mr. Chaudhary, if the award is of 2018 and Perkins came in 2022, I think, then how would this be relevant? You can say TRF, Energo and all that.
No, my lord, this is relevant, my lord. This has only interpreted the law, my lord. So far as the changes are concerned, it has come in 2015. The statutory amendments, my lord, by reason of section 12 and all that. So
12(5).
that has come in 2015. And even this provides
with effect from 2015. When was it?
With effect from 20. Well, that is with effect from 2015 is 36, my lord, that proviso. I'll tell you.
No, and that 12(5)?
Schedule also is with effect from 2015. October 2015.
With effect from when did they come in? Because I have to know whether at the time of delivering the award, the law was there or not.
Yes, well, it had come in, the date is 23rd October 2015.
With effect from?
23rd October 2015.
Yes, but the Amendment Act is of 2016, is it not?
Amendment Act is of 2016 with effect from 23rd October 2015. And Miller, so far as the proviso is concerned, that's an amendment of 2021 with retrospective effect from 2015. The fraud which entitles me to unconditional stay.
But the second proviso.
The second proviso, and in any event, my lord, even the pleading when it was filed, my lord, the pleading of fraud is already there in the main section 34. It's not that in this 36(3) we have made out this case.
Yes.
Lord, kindly consider the Cholamandalam investment judgment. 2023 SCC Online Calcutta 605. So this is of course, my lord, section 47 stage, my lord. Section 47 was also construed over here, but my lord, I'll just point out the two paragraphs.
Yes.
Kindly comes to para 23. I make it clear that the observations in this judgment remain applicable and limited to awards wherein arbitral proceedings commence post 2015 amendment to the Act. I have not examined or dealt with the conundrum of proceedings having been initiated pre-2015 amendment and concluding post-2015. From the analysis undertaken above, the principles that emanate are extracted below. As held in HRD Crop, arbitrators falling under Schedule 7 of the Act are ineligible as they lack inherent jurisdiction. Such ineligibility was extended to persons appointed by persons falling under Schedule 7 of the Act in TRF Limited. This ineligibility was ultimately extended to parties who are unilaterally appointed by one of the parties to the arbitration in Perkins. The Apex Court has judicially expanded Schedule 7 of the Act to include persons unilaterally appointed by one of the parties vide its judgment in Perkins and or persons appointed by persons falling under Schedule 7 of the Act vide its judgment under TRF. It is a settled principle of law that compliance with Section 12(5) read with Schedule 7 is the sine qua non for any arbitral reference to gain recognition, and validity before the courts. An arbitral reference which begins with an illegal act vitiates the entire arbitral proceedings from the inception, and same cannot be validated at any later stage. Thus, it would be a logical inference to consider such arbitral proceedings as void ab initio. Awards passed unilaterally by a unilaterally appointed arbitrator are non-est in the eye of law. While Section 47 of CPC is not directly applicable, guidance has to be sought from the jurisprudence of the apex court vis-a-vis decrees passed while lacking inherent jurisdiction. Decrees do not exist in the eye of law, and similarly, awards passed by lacking inherent jurisdiction can be said to have never existed. Therefore, the parties would be free to re-agitate the matter. Well, it will kindly come to one more line. Well, at para 25. The law of arbitration is an alternative dispute resolution mechanism that was brought into statute books in order to facilitate a quick and efficient method of dispute resolution. The raison d'etre of arbitration is to provide liberty to parties wherein they can decide upon various facets
Mr. Chaudhary, just tell me what the point is.
Well, only point
What
is,
is,
my lord, that
what is this
unilateral.
small guy? Who is this small guy?
Well, this is an analogy. Small guy analogy has been drawn by the learned judge. Kindly come from in conclusion. Last 6 lines. In conclusion, one may say that apparent impartiality that existed providing power to one of the parties to choose the arbitrator unilaterally has been taken away, as the same was fraught with inequalities at the very threshold of the initiation of arbitration proceedings. However, proviso to Section 12(5) of the Act allows for waiver but clarifies that the same has to be explicit and in writing. Here, my lord, our first, from day one, our case is there is no arbitration agreement at all. And even if it is assumed there is, my lord, the clause itself is that they will appoint the arbitrator, which they had done. So, my lord, this is also applicable over here. And, my lord, this itself, one more last judgment, my lord.
So the point of this decision is that if it's a unilateral agreement appointment, then the arbitration, the award becomes void ab initio. That is the point.
Kindly see it from a slightly different point of view. But I had already shown to your lordship, our contract was valued at rupees 6 lakhs. That comb contract, 9 lakhs, I'm sorry, 9 lakhs. And my lord, the award we suffer is of 40 lakhs. Sorry, 60 lakhs, being 10% of the contract value. So, my lord, if I am to secure it to get it set aside, my lord, iniquity is such, my lord, it will be not possible at all. My lord, I suffer something, and contrary to Section 73, my lord, consequential damage and remote damage, my lord, contrary to Section 73, that, my lord, a comb, I have to foresee that they will use it with a white vest, and, my lord, there will be colored spillage and it will affect the entire lot. And the case made out also was not true. But one more judgment, lordship will see, my lord, this is the Delhi High Court judgment, 2023 SCC Online Delhi 3148. This is after considering, that same paragraph of Govind Rava, I'm sorry. Govind Rava, TRF, Parkins, all been considered. Sorry, not Govind. This is Govind Singh. This is a different one. Kindly comes to para 9.
Govind Singh. I can see Narendra Kumar Prajapat.
No, Govind Singh is in para 12. Kindly comes to para 9. In view of the above, the failure, if any, on the part of the respondent to object to the unilateral appointment of the sole arbitrator cannot be construed as waiver of his right under 12(5) of the Act. The award rendered by an arbitrator who is ineligible to be appointed as such cannot be enforced. And then, my lord, HRD Corporation, the Supreme Court judgment has been quoted. Then, my lord, paragraph 12, Govind Singh has been quoted. I just read that quote, my lord. In view of the above, the remaining question to be addressed is whether an arbitral award rendered by a person who is ineligible to act as an arbitrator is valid on binding on the parties. Clearly, the answer must be in the negative. The arbitral award rendered by a person who is ineligible to act as an arbitrator cannot be considered as an arbitral award. The ineligibility of the arbitrator goes to the root of his jurisdiction. Plainly, an arbitral award rendered by the arbitral tribunal which lacks the inherent jurisdiction cannot be considered as valid. In the aforesaid case, the impugned award is liable to be set aside as being wholly without jurisdiction. The learned commercial court, para 13, has held that an award rendered by a person who is ineligible to act as an arbitrator by virtue of provisions of 12(5) of the Act is a nullity and therefore cannot be enforced. It has accordingly dismissed the enforcement petition under Section 36 of the Act with the cost quantified at 25,000. Now, this was also a consideration at the Section 36 stage. That is why, my lord, I am relying on. And then, my lord, para 14. This court finds no infirmity with the aforesaid view. A person who is ineligible to act as an arbitrator lacks the inherent jurisdiction to render an arbitral award under the Arbitration Conciliation Act. It is straight law that a decision by any authority which lacks inherent jurisdiction to make such a decision cannot be considered as valid. Thus, clearly, such an impugned award cannot be enforced. This is also a division bench judgment, my lord, and I have another division bench judgment which has followed it. That
on the same point.
On the same point that, my lord, under Section 36 stage also, this can be a germane consideration, my lord, while considering an application under Section 36. So, my lord, at this stage, my lord, if I may sum up, my lord, prayer B, lordship will consider, which is, my lord, for early hearing of the 34, because, my lord, it will come back to your lordship. We just need to recap. Summarizing, my lord, why we are asking for a stay. Prima facie, there is no arbitration agreement. Secondly, assuming that there can be an arbitration agreement, my lord, it's a unilateral appointment clause, and, my lord, it is vitiated ab initio. And thirdly, my lord, the rendering of the award has been vitiated by fraud because, my lord, at none of the stage, the arbitrator, my lord, decides the issue whether there is an arbitration agreement under Section 7. None of the stage, thrice. And, my lord, therefore, my lord, my respectful submission is kindly pass an unconditional stay so far as this is concerned.
Mr. Mitra, how much time will you take?
It will take some time, half an hour.
Half an hour? Then what to do? Come back in January? What is it that you want, Mr. Chaudhary?
My lord, now that the execution has come before your lordship, my lord,
there's no problem.
There is no, hopefully there is no problem, but, my lord, they are still entitled to, my lord, press for the execution application even before your lordship.
No, I will record that Mr. Mitra wants it after the vacation. Yes.
Oh, I am told, my lord, it has not yet been assigned before your
Justice Kapoor, when released the matter, has recorded that the other two matters are before different court. Then all lies that should go before that court. We received a phone call from the OSD officer in charge of that, and where is that? So we have mentioned my lord's court to the officer that the other matters are before my lord.
Very well. So if I record that that application is on its way to be listed, then that solves the problem for Mr. Chaudhary.
My lord, I don't know, my lord, if it is not before your lordship, it might not solve the problem.
Yes.
Because,
Yes.
my lord, they go and take a different stand when it is another court. They were pressing the execution application. My learned friend's junior was there, my lord.
I was not there.
I was.
My lord, by that time, this 36 didn't appear before your lordship. It was there in that court.
He said that there is no stay. I am entitled to order of
Very well.
injunction.
Learned counsel appearing for the petitioner award debtor has concluded his submissions. Concludes his submissions on the issue as to why the award is required to be unconditionally stayed. As to the reason for unconditional stay of the award, of the impugned award. Stop. Next, learned counsel opinion for the award holder seeks to make his submissions in January 2024. Stop. Next, the court is also informed that the respondent's execution application may be assigned to this court. Stop. Next, list this matter. Give me a date, Mr. Mitra.
January, whatever date. হ্যাঁ 2 তারিখে খুলছে মানে হ্যাঁ
Second week, first week?
8th is a Monday মানে or the month release date for the month.
This is matter on 9th January 2024.
We will make it on 8th or 10th. Or
On
we can
10th.
come back in the first week also, 4th, 5th, whatever. Maybe we get 4th or 5th.
Give me your diary. Yes.
4th or 5th, any day. 4th or
Yes.
5th. 4th or 5th.
List is matter on 5th January
5th, yeah,
2024
deeply
as prayed for, along with the execution application if filed by that time, by the returnable date.
নিয়ে তো অফিসারকে বলে আনিয়ে দাও না ডিপলি অ্যাপ্লাই
Six, Kochar Infotech Private Limited.
My lord, this is my Section 9 petition. My lord, I must confess, my lord, this ought to have been filed in the commercial division. The claim is above 10 lakhs, my lord, and it
So
arises.
file it.
No, would your
Except
lordship,
that it will not be taken up this side of the vacation.
my lord, no difficulty, my lord, your lordship may, my lord, kindly direct.
Yes, learned counsel, why? 21C?
Sorry, my lord.
21C or pecuniary?
No, no, both pecuniary and, my lord, it arises out of an IT agreement for, and the claim is
What
against
IT agreement?
information technology, my lord.
Don't say IT.
And I'm
Yes,
sorry.
so that's 21C, which one?
And the claim, my lord, arises out of invoices raised. So
That's 21C, which division?
I will tell your lordship, my lord.
Commercial code star দাও তো।
Sixteen, my lord. Technology development agreements.
And the claim is above?
The claim is above 10 lakhs, about 58 lakhs. In paragraph 4, my lord,
Yes, learned counsel agreeing with the petitioner seeks to move this application in the commercial division of this court on the ground that apart from the dispute being covered under section 2 within brackets 1 within brackets small c within brackets x5i XVI small of the Commercial Courts Act, 2015, the claim is also the claim also exceeds rupees 10 lakhs. Stop. How much is the claim, did you say?
my lord, I'll just tell you. As of October 2022, the claim was 58 lakhs 13,720.
Next, list this matter on. Give me a date, please, Mr. Lakmani.
Lord, as per my lord's convenience, upon reopening, any day, my lord.
List this matter on 9 January 2024. Stop. Have you not served them?
My lord, we have, but the affidavit of service has not been prepared yet. We will file it, my lord, on the returnable date.
Yes, affidavit of service to be filed on the returnable date and stop. The petitioner will also communicate this order on the respondents.
My lord, there is a supplementary affidavit, my lord, which I was proposing to file. My lord, would your lordship accept it today or
No,
may I
no.
tender it?
Not required.
I'm sorry.
On the return. The department, the matter should be transferred to the commercial division and the department shall take steps accordingly.
I'm grateful, my lord.
না এটা কাজ করো তো তাহলে তো ডেট হবে না ডেটটা ছেড়ে দাও কেটে দাও let the matter be transferred to the commercial division and the department shall take steps accordingly. Stop liberty to mention.
I'm grateful, my lord.
Item number 7, HON'BLE International.
Lordship,
by application under 11.
Lordship, item 7, may I pray for a note today on grounds of Mr. Rudraman Bhattacharya? He was in court, but he suddenly fell ill, so he left during the recess, Lordship. If the matter can be kept tomorrow, Lordship.
Yes, this is the second consecutive prayer for adjournment made on behalf of the respondents. Stop. Consecutive kirdo. Adjournment is paid for on behalf of counsel appearing for the of the respondents. Stop list this matter tomorrow. Tomorrow is all right for you?
Item number 8, Marlin projects.
This is my Section 11 application, my lord. On the last occasion, my lord, I had given an overview as to what my case is. This, and in fact, my learned friend was to file her wakalatnama in respect of the respondent.
Yes, have you done that?
Yes. My lord, I can briefly, my lord, recapitulate. My lord, 2nd July 2018 is a joint development agreement.
Yes.
In terms of the agreement, about 60 kathas of land were to be jointly developed. There is, my lord, an arbitration clause in the agreement, clause 21.1, my lord, which is at page 51.
Yes.
And pursuant to the agreement, a registered power of attorney was also executed, which is, my lord, at page 109. In between, my lord, there was some disputes which had taken place. We found out that there are substantial encumbrances in respect of the property. There were also other third parties who had come and disturbed our possession. And ultimately, we figured out that the area of the land, which is under what's to be developed, has been reduced from 60 kathas, with actually area is about 22 kathas. Now, when we were trying to give effect to the agreement in different manner, even with the reduced area, we were served with a notice of threatening termination, 4th of January 2023, that is by the respondents, page 197, where they threatened to terminate the joint venture agreement and the power of attorney. We gave a detailed reply to it. Page 200 is my reply, to which there were also a correspondence. They had given a reply that is at page 204 of 18 February 2023. So therefore, there was a dispute. They had threatened to terminate the joint venture agreement. We disputed the termination. We have also put them on notice that we have taken several steps in terms of the agreement, whereas they had failed to discharge their obligations. And then there was a section 21 notice given on 27 June 2023 by us, which is at page 228. And in the meantime, we also moved the section 9 court before the learned district judge at Alipur and obtained an order of status quo, which is, my lord, page 224 of order of 17th May 2023, page 224. So there is a status quo in respect of the property as on date. The order has been extended from time to time and it is subsisting as on date. Now, then
you withdrew the section 11.
Yes, there's a section 11, my lord. We had filed, but there were some defects in the section 11 application. Your lordship's order is at page 249, by which your lordship had granted liberty to file afresh, and we have filed this section 11 application.
Yes.
Well, there is no, they have only threatened to terminate the joint venture agreement.
What is the claim you said? 2 crore.
About, my lord, there would be, because I may have a specific performance claim also, in addition damages. I've incurred expenses about 2 crores to that effect. So my claim would be over and above that amount, the monetary claim.
Yes. What do you have to say?
Lordship kindly comes to the section,
microphone, please.
Lordship kindly comes to the section 21 notice, Lordship. Page 239 at page
228.
It starts from page 228, Lordship. Kindly comes to page 238, paragraph 40, Lordship.
Yes.
For the reasons as stated herein above, and by virtue of the said agreement, coupled with irrevocable power of attorney as referred to herein above, which form a part of the composite transaction, we have acquired right, title, and or interest in respect of at least the Schedule B property, if not more. It is evident from your conduct that you are interfering with and or are seeking to infringe upon the right which is not permissible in the eye of law. Lordship, they are disputing the right, title, and interest, which is not an arbitrable dispute. That is all.
Yes.
Well, the right is acquired under the agreement. So the agreement they threaten to terminate. So that is, my lord, exactly what we have, my lord, sought to state in our section 21 notice, that I have acquired right by virtue of the agreement which you are interfering. That is absolutely has to be covered by the arbitration agreement. There is an arbitration agreement. So, my lord, that's my submission.
The respondents are now represented. Stop. Next, and have filed their wakalatnama. One Vakalatnama?
Yes, Lordship, one wakalat.
Yes, are now represented. Stop. Bakire Kirita. The dispute between the parties arises out of a joint development agreement dated 2nd July 2018, by which the petitioner, as the developer, paid 50 lakhs to the respondents' landowners. Stop. The petitioner was to develop 60 kathas, COTTAHS, kathas of land, along with who?
Well, with the owners.
Along with the respondents. Stop. Several steps towards the construction were carried out, including mutations in respect of the land, including mutation in respect of the land. Stop. The respondents, however, terminated the agreement on 4th January 2023 on the ground of what? Delay.
It is not yet terminated, Lordship.
It's threatened to terminate.
It is not terminated.
On the ground of?
Delay.
The respondents, however, threatened to terminate the joint development agreement by way of a letter dated 4th January 2023 on the ground of delay on the part of the petitioner. Stop. The petitioner replied to this notice on 23rd January 2023, and the respondent thereafter on 18th February 2023. Stop. The petitioner also applied next. The petitioner also applied for interim protection from the learned Alipur court.
District Judge.
From the learned Alipur court, whereby the petitioner obtained an order on 17th May 2023, restraining the respondent from disturbing the what?
There is a status quo in respect of the property.
Restraining the respondent from disturbing the state of affairs in the said property. Stop. The petitioner thereafter issued the notice invoking arbitration on 27 June 2023. And stop. The petitioner, the court is also informed that the petitioner withdrew and that the petitioner was given liberty to withdraw an earlier application under section 11 by an order dated 5th October 2023. Stop. Next. The dispute would be evident from the section 21 notice issued by the petitioner. Stop. The petitioner has as well as the letters exchanged between the parties after the respondent threatened to terminate the agreement. Stop. The petitioner now claims refund of the return of the investments made by the petitioner for the joint development of the concerned project. Stop. Next, the arbitration agreement contained where is the first page?
Well, it starts at page 28.
Yes, contained in the development agreement dated 2nd July 2018 covers the disputes and differences which have now arisen between the parties post-termination. Stop. The objection taken on behalf of the respondents that the dispute is questions is a matter of title is not acceptable, since the petitioner is claiming its rights under the development agreement. Stop. It is the respondents do not say that the respondents were not parties to the arbitration agreement. Stop. Next. AP 750/2023 is accordingly allowed and disposed of by appointing blank to be informed by 20th December 2023.
Item number 9, Sri Babu Nanda Mishra.
My lord, I am appealing for the petition.
Item number 9, my lord. I am for the respondent number 1, my lord. I have not received any vokalatnama till now, my lord. Your lordship.
Where are you? Where are you based?
He is Darjeeling, my lord.
Darjeeling.
Yes.
You want to go there to get the vakalatnama?
No, my lord. Amit Sinha, advocate, my lord, he is also he is conducting advocate. Due to his personal difficulty, he not come to this week, my lord. Your lordship will take up the matter after vacation, my lord.
Section 11?
Yes,
My lord, this is section 11 application. My lord, my application, my lord. My lord, the claim is around, my lord, 64 lakhs and odd. My lord, the basic grievance of the petitioner is that, my lord, the petitioner being one of the partners of the partnership firm who is running, my lord, a care nursing home, my lord, they are not being able to enter into the compound of the nursing home. And my lord, there is a huge profit which is going on, my lord, by way of running of nursing home. My lord, they are not giving us, my lord, our, my lord, part of profit. My lord, that is my sum and substance of the dispute. Milord, we Milord took out a Section 9 application. Section 9 Milord application was disposed of, Milord granting an order of injunction that they can't restrain us from entering into the compound. Now, Milord, we sent a letter of request, Milord.
No, it's a Section 11. You want appointment of an arbitrator?
Yes, Milord.
Yes.
Milord, we Milord sent a letter of request, Milord, that is at page 58A. Milord, naming Milord an arbitrator, which Milord they by way of a reply they have refused.
Mr. Mundul, I'm keeping this matter day after tomorrow. You get your vakalatnama.
If I able to collect the vokalatnama, I come for your
No,
lordship.
then otherwise I will pass orders.
Yes, lordship.
All right. I'm at best I can keep it on Thursday. I'm not going to decide on any dispute. I'm just simply going to appoint an arbitrator.
Well, I take instruction.
Enough time for you to travel to Darjeeling and come back by then.
Your lordship, I take instruction, my lord, and come.
Instruction. If you're not here with the vakalatnama, orders. Yes. This is learned the advocate on Mr. L. Mundul. Do you spell it M-A-N-D-L?
M-A-N-D-L.
M-A-N-D-L, who proposes to act for the respondents,
Only
comma,
one.
respond number 1, comma, seeks to file the vakalatnama, stop list this matter on 21st December 2023. Stop. What about the other respondents?
Milord, respondent number 3 already served. 2, Milord, it's sending, Milord, not confirmed, but Milord, delivered to Milord the head office. Dharmotala, it's Dharmoshala head office, Milord, I stand corrected. It's showing, Milord, Milord, that is respondent number 2, one of the partners, Milord. Milord, I'll take, Milord, the updated printout, Milord.
Very well. Next, learned counsel appealing for the petitioner submits that the other 2 respondents have already been served. Yes, you better file an affidavit of service on the next day. Where is it?
Milord, the affidavit of service is here, Milord.
File it on the next day. And the petitioner is given leave to file an updated affidavit of service on the returnable date.
Grateful, Milord.
Item number 10, Soibal Kumar Goin.
Lordship, in this matter, I have received instruction from my client to appear in this matter. Lordship, but the vakalatnama has not yet been signed by my client. Kindly keep it day after tomorrow.
Day after tomorrow. Yes, sir. List this matter on 20th December 2023 as paid for on behalf of the respondent.
Item number 11, Nisha Sky Cover.
My application for substitute arbitrator. So, now the respondent is appearing.
I'm appearing for the respondent, Your Lordship.
Yes.
Dispute arising out of a development agreement, by which we had paid a sum of rupees 1.25 crores. Now we have terminated the agreement. We are sought for refund. Initially, Section 21 was given there. We appointed a sole arbitrator. They rejected that name. Appointed a nominee arbitrator. The nominee arbitrator came and recused herself from the proceeding. So it was lying at that. Now we are before your lordship. If your lordship is so direct and appoint, I believe my learned friend is not opposing to the arbitration clause or the
not opposing to the appointment of the arbitrator. Your lordship kindly allows prayer A in terms of their prayer A.
That's the appointment.
Appointment of one single arbitrator. Your lordship.
Yes, if your lordship kindly looks at the clause,
Yes.
Well, it starts at page 22, the development agreement. Page 44 is the arbitration clause. Clause 17. Well, in the event of any disputes or differences between the parties hereto regarding the interpretation or application of the agreement or any part thereof, the parties shall try to resolve or amicably settle the same through mutual discussions, negotiations, mediation by common friends, or arbitration. In the case of arbitration, the parties shall first mutually try to appoint a sole arbitrator, failing which one arbitrator each will be appointed by the owner. So I've given a prayer so that because the quantum or the claim is of only 1.25 crores and consequential interest that I'll be paying. The Lordship pleases to appoint a sole arbitrator in terms of the agreement. And your Lordship may also kindly look into the recusal of the arbitrator appointed by them. Page 94 is the email.
What is page 72?
Lordship, page 72
is what? What are all this?
This is your lordship, the reinstatement plan that is arising out of that agreement.
The development agreements, the brochure, which is the yes.
Very well. Yes, Mr. Shorkar. So, according to you, the arbitration clause, and then what were you saying? What did you say?
The recusal, where the nominee arbitrator had recused herself. Page 94 is the email by which they have recused.
Why are you going on disturbing the court? Your learned friend is making submissions. You have announced your opinion right or what? Yes. Page 94. Yes. You will find an email of 25th of January 2021 by which Mr. Chorati shows me what was the nominee arbitrator of the electronic and
Yes, there has been certain delay on our part, but it's within the section 21 notice. If your lordship kindly sees, that's on at page 88. It's of 17th of August 2020. So the limitation with regard to the dispute starts running from 17th of August 2020.
That's page?
Page 88. 17th of August 2020, your lordship will find. And the arbitrator that we had appointed is at page 90. Paragraph 6.
Yes. So how does page 88 help you? The section 21 notice?
Commencement of arbitral proceedings, section 21, it commences from from that day.
And under section 15, what is the ground for seeking? This is a section 15 application.
Yes, read with 11.
Yes, read with 11. So 15, there are grounds appearing in 14.
Yes.
What are the grounds in 15 for?
There is a ground of recusal as well. Lordship may kindly allow.
Withdraws from the proceedings.
Yes, if your lordship kindly sees section 15, I'll just indicate. C, I believe, may I read section 15? In addition to the circumstances referred to in section 13 or section 14, the mandate of the arbitrator shall terminate where he withdraws from office for any reason.
Very well. What is the quantification of the claim?
1.25 crores along with interest.
Yes. Yes, Mr. Chakraborty.
My lord, page
microphone, please. Are you opposing the appointment?
My lord, if this honorable could kindly permit the sole arbitrator to be entrusted with this particular matter, my lord, we have got no objection.
Very well.
Instead of my lord, the arbitration clause.
Yes, the instead of
the arbitration clause is 3-member arbitral tribunal.
Yes,
Here we are praying
yes,
the court intervention and appointment.
Yes, the application is for appointment of a substitute arbitrator. Stop. Next, learned counsel opinion for the petitioner has taken the court through the relevant documents, starting from a development agreement of what is the date?
27 September 2016.
27 September 2016, which contains the arbitration clause at clause 17.1 and the section and the invocation notice issued by the petitioner on 17th August 2020. Stop. Next, the court is informed that the learned arbitrator who was appointed thereafter, who was appointed by the parties, recused from the arbitration by a mail dated 25th January 2021 on the ground of bad health, on the ground of personal difficulties. On the ground of personal difficulties, stop. Counsel submits that the parties thereafter tried various means to resolve disputes between them, but were unable to do so. Stop. The present application was filed in December 2023. Stop. Next, since an arbitrator, since the parties were already in arbitration, there is no requirement now, there is no need at this stage to dwell on the disputes between the parties. Stop. Having regard to the petitioner's claim of rupees 1.25 crores against the respondent, and the fact that Section 15 of the 1996 Act allows for appointment of a substitute arbitrator on the erstwhile arbitrator withdrawing from the proceedings, AP 848 of 2023 is allowed and disposed of by appointing blank to act as the arbitrator, to be informed, to be communicated by 20th December 2023.
Your Lordship, had directed fresh service. May I file the affidavit of service?
Yes, the affidavit of service is kept.
Lordship has appointed a sole arbitrator in the grateful.
No, but even the earlier arbitrator was a sole arbitrator.
No, what happened was, we initiated, we gave a Section 21 notice. The name we suggested, they did not agree to that name. They gave their nominee. So hence, the first year had failed.
Very well. At a line at they the parties agree. Council opinion for the parties pray for appointment of a sole arbitrator.
I'm so.
Well, Lordship appearing for respondent number 2, my lord.
Yes.
Yes, my lord, this is my section 11, my lord, arising out of a development agreement dated 11 July 2014. My lord, there are two respondents. My lord, pursuant to your lordship's earlier directions, we once again attempted to serve on the respondent number 1, my lord, but respondent number 2 is here. But unfortunately, my lord, the endorsement says that the company has left the address without instructions, my lord. The company
When was the earlier first time you tried to serve?
My lord, it was on. Well, the first service was attempted on. But we had posted it on 11th of December. On 13th of December, the endorsement came that the company, the address is absent, my lord.
No, this was the second time.
Second time, my lord.
And the
first
first
one was attempted on 11th of December, my lord.
So 11th of December and 13th of December. Twice. Yes.
But the respondent number 2 is the director of the respondent number 1, my lord, to whom the power of attorney was given, my lord. But what had happened is, my lord, a development agreement was entered into between the parties. for construction of flats, my lord, in which the petitioners were allocated 1 flats each.
So you're the owners?
I'm the owner of the land.
Yes.
Well, the flats were given to us in 2019.
Yes.
But what had happened is the dispute arises out of the fact that the developer failed to perform his contractual obligations under the development agreement insofar as the constructions were not made, my lord, as per the particulars which the parties had agreed upon. But I have stated in paragraph 7, page 5, the breaches in the agreement which the developer had made. But by virtue of that, my lord, I had invoked the arbitration clause, my lord. I had sent the section 21 notice, my lord, which is at page 132. Well, there is a reply also to the section 21 notice on behalf of the respondent number 2.
What is the date of the section 21?
My lord, it is 16th of February 2023, my lord. Page 132.
132? Yes, it is. Yes.
But before that, if your lordship kindly comes to page 6 of the petition, my lord, paragraph 7.
Yes.
But these are the breaches which had been committed by the developer in terms of the development agreement, my lord. But until date, my lord, the completion certificate has not been given to us. So a specific averment to
When was it supposed to be given?
But in 2019, when the position was handed over.
And they replied to the 21?
Yes, my lord, that is at page 140. But the respondent number 2 replied.
Saying what?
My lord, the principal contention is, my lord, since position had already been given in 2019, no complaints had been raised at that point of time. So he says that it is time barred and these disputes cannot be adjudicated into. My lord, but the fact remains, my lord, the completion certificate till date is yet to be obtained, my lord.
Very well. Yes, Mr.
Yes, my lord.
Yes.
My lord, may I say, my lord, I am the erstwhile director, my lord. I had already resigned on 17th of August 2022, and that the petitioner is always aware of the same, my lord. If your lordship kindly come to the very reply, even at internal page 2 of the reply, lordship, at second paragraph, I had pointed out the same, and my lordship will find also the same embodiment in the petition also at page 8, para 12, my lord, and they have not raised any dispute even, my lord. That is not a disputed position, my lord.
Yes.
If my lord kindly see, my lord, already, my lord, in August 2022, my lord, I have already resigned, my lord, from the board, my lord. I am no one in the company at present, my lord. If your lordship kindly come to page 8 once, my lord, at para 12, my lord, it is their averment. Your petitioner states that the respondent number 2 sent a letter on April 6, 2023 through the learned advocate stating that he resigned from the office of the respondent number 1. And for that reason, there is no arbitral dispute between the respondent number 2 and the petitioners. It is their averment, my lord.
Yes.
So, my lord, I have only prayer subject to your lordship's permission, my lord, that may I be removed from the area of the respondent. My lord, it can, my lord, against the company, my lord, it can go on, my lord. May I be removed, because since they have already made a categoric submission in their petition and they have not raised any dispute to such position.
Very well. Yes, Mr. Mukherjee.
Yes. What my learned friend says in paragraph 12 is what I have set out from his reply in verbatim. It is not my assertion that he is not to be, since he has resigned from the office of the company, that the arbitral disputes cannot lie against him. At that pertinent point of time, my lord, in 2014, when the agreement was entered into, he was a director. The power of attorney was also given to him. The power of attorney is annexed to this, my lord. Subsequently, my lord, in view of the breaches, my lord, the power of attorney was revoked also. My lord, the section 21 notice was sent to him also. He replied to that. My lord, just not being a director of the company and resigning in 2022, when position was already given to me in 2019, cannot absolve him, my lord, from this most liability.
May I?
Yes.
Most importantly, my lord, they have not raised any dispute relating to such averment, my lord. They say that they have already only
Yes,
recorded
not
my
required. Yes, the petitioner has made 2 attempts at serving the respondent number 1, but has been unsuccessful. Stop. The respondent number 2 is represented. Stop. Next, the dispute between the parties arises out of a development agreement, capitals, dated 11 July 2014, between the petitioners / landowners and the respondents / developers. Stop. The respondents were to construct flats on the petitioner's land. Stop. The petitioners were given possession of these flats in 2019, but complaints of several breaches on the part of the respondents stop. No, but complaints that the respondents have breached several terms of the development agreement. Stop. The petitioners complain that despite being put in possession of the flats in 2019, the respondents are yet to hand over the completion certificate of the pertaining to the building /flats pertaining to the building. Stop. The petitioners invoked the arbitration clause contained in the development agreement on 16 February 2023, and the respondents replied to the same on
April 6, 2023.
6th April 2023, disputing the existence of the arbitration agreement. Stop. The respondents also say that the petitioners claim, if any, petitioners apostrophe, claim, if any, is time barred. Stop. Next, the primary contention of the respondent number 2 is that the respondent number 2 resigned from the respondent number 1 and is no longer involved in the dispute and should therefore be absolved from the dispute and should therefore be deleted from the arraignment of parties and should therefore be deleted from the arraignment of parties. Stop. Next, it however appears to be an admitted fact that the respondent number 2 was a director of the respondent number 1 and was also holder of the power of attorney at the relevant point of time. Stop. The very fact that the respondents have not handed over the completion certificate of the building in question to the petitioners itself beats beats any argument on limitation. Stop. The disputes are apparent and as also outlined in paragraph 7 of the petition with regard to the alleged breach committed by the respondents. Stop. The disputes are also relatable to the arbitration agreement contained in the development to the arbitration agreement. Stop. How much is your claim?
My lord, there's no monetary claim, my lord. It's only a few.
Just quantify it, please.
They have not quantified, my lord. It is not quantified because there are certain constructions which has to be made.
It will just help me to choose the arbitrator. Please don't argue with the court and be silly.
No, it will be around 25 to 30 lakhs, my lord, not much.
Yes, AP 3849 of 2023 is accordingly allowed and disposed of by appointing blank.
But only one thing, if the arbitration clause says of a 3-member tribunal, my lord. But if your lordship agrees, my lord, your lordship
Why should
considers.
I
my
agree? It's up
lordship
to you to agree.
It can be a sole arbitrator, my lord, since in view of the.
Yes, yes, what did you want to say?
My lord, the only two things I would like to indicate.
In
my lord. First
1
of all,
minute, please.
My lord, in paragraph 7, my lord, lordship, they have categoric allegation only against the respondent, not respondents. Lordship.
Very well, sort it out
And
in arbitration. Yes,
may my point of relating to contention that I have placed here, my lord, may I
yes,
be
yes, of
permitted?
course.
Yes, ma'am. And
Yes,
the
parties agree.
completion certificate has already been given. My lord, in
Parties agree that
2019. That is recorded.
one arbitrator may be appointed. Parties agree that a sole arbitrator may be appointed to adjudicate on the disputes. Stop next. AP 849 of 2023 is accordingly allowed and disposed of by appointing blank. To be informed, to be communicated by 20th December. Stop. Next, the respondent shall be at the respondent number 2 shall be at liberty of taking the point of resignation from the respondent number 1 in the arbitration.
Grateful, lordship.
Yeah, appellate side.
Before lordship takes up appellate side, may I seek an extreme indulgence, my lord? The interim order in a commercial matter is expiring today. May I only request your lordship to keep it as to be.
Why did you not mention it to
my
me
lord? We
today
should
morning?
have, my lord. We don't have an explanation for that. I was, my lord, reprimanding my junior for that. My lord, we should have. It's ODC 78, but I take the responsibility, my lord.
Thursday. Mentioned on Thursday. You can't mention or at any point of time. Yes, appellate side.
Appellate side daily list item number 1, Torrent Minerals Private Limited.
My lord, one last judgment, my lord, before I start dealing with their judgment, that is on the same proposition that only because you have made out a good case, assuming the
yes.
No, I don't know. Even if there was a right of hearing, we denied them.
Yes.
And it was wrong on our part to blacklist him, or the lifetime blacklisting without giving them an opportunity of hearing. Even then,
yes,
the court will refuse. The court may refuse to grant such order if the facts of the case so
You're relying on this.
One more judgment, Lordship, one more judgment.
Have you given to Mr. Mukherjee?
I shall.
Yes.
It will be given just now, madam. Paragraph 11.
11.
Yes. The first question which arises for our consideration is whether the High Court committed an error by not setting aside the accusation after recording or finding that the orders by which subsection 1741 were invoked were illegal. We may note here that after invoking the urgency clause and dispensing with an inquiry under 5A, Section 6 declaration was issued on 17th March 2008. All the writ petitions filed by the owners were belatedly filed after more than 3-4 years. I will show there was delay here also in the context from the date of declaration under Section 6. It is true that the High Court was right in holding that the urgency clause could not have been invoked in the facts of the case. However, a finding of fact has been recorded by the High Court, and after the possession of the acquired land was handed over to the acquiring body, the same has been developed and allotted to third parties. A very large area of 108 acres owned by various individuals was acquired. However, only 11 persons claiming to be the landowners belatedly filed writ petitions. Taking note of these facts, the High Court, for balancing the private interest of the landowners with the public interest, declined to quash the acquisition proceedings.
High Court passed an order directing that the compensation shall be payable in terms of Section 213 of the Act. Writ jurisdiction under Article 226 of the Constitution is always discretionary. It is an equitable remedy. It is not necessary for the High Court to correct each and every illegality. Well, this is what I am. If the correction of illegality is not likely to have is likely to have unjust results, High Court would normally refuse to exercise its jurisdiction under Article 226. Well, I am on this. So even though the accusation was bad,
what is the unjust demand here? That despite they being caught red-handed, they are still trying to
they are
continue.
even after the blacklisting, they are continuing with that. That's one aspect that I have shown post-writ petition, no opposition filed. And second aspect, here public interest, because I've got 100 plot owners, plot holders inside an encircled area.
Yes.
And there were repeated complaints, and it was found that they were caught red-handed.
Yes.
And this is not something, a monopoly I have. Land, go downs in that port area. So this is in addition to Justice Dotto's judgment, which I had cited earlier. Just because it's an illegal order does not mean, but here, of course, I'm not saying it's illegal, because the right of hearing in a blacklisting case is not, at least not there in law. Lordship can hold in certain situations, it may have been required, but then they should have come forward at that time. They did not come forward when we gave them the notice. They didn't ask for an opportunity of hearing. They did not deny the. Secondly, Lordship will see in this context of delay also.
Yes.
Their land acquisition 3-4 years. Here, the blacklisting happened in the month of October of. October of 90. The blacklisting here happened in the month of October 2020. 13th October 2020. The writ petition is filed by them only in April 2021. It is not something blacklisting has happened, then they came 6 months later.
Yes.
And that too, one of them, that's a different.
Yes.
Same owner, 2 entities, both blacklisted. Now they want entry through either one. One of them who was caught red-handed, stealing, has not come forward. The one who was, the other one with the same owner has come forward. So they want an entry through this back door. Because here it's a plot holder. So I was not caught red-handed. It was my sister concerned. So they want entry in this way. That too 6 months later. I shall now come to the judgment cited by the.
You want to distinguish them?
By the respondents.
Yes.
So the principal judgment, which is the common carrier, may I deal with that first? The division bench of Justice in Rashmi Metallics, Jyotirmoy Bhattacharya, Justice Taposh Mukherjee has. Rashmi, division bench, Jyotirmoy Bhattacharya, Taposh Mukherjee. Well, first and foremost, while a railway statutorily is a common carrier. They have
Railways, sorry?
Is a common carrier statutorily.
Yes.
They carry cargo for the people, and they have a monopoly in that. Well, we do not carry anything. Allotting plots of land has nothing to do with common carrier. This is too far.
It's one of Mr. Dotto's arguments,
Yes.
which I think mentioned, which I mentioned last.
And this was their principal argument, if I may say so, because although others were in passing that no opportunity of hearing, because judgments are against him. But common carrier, I am a common carrier, so I can't be. I am a common carrier, but how can a common carrier can be bus, can be truck? It is statutorily defined under the Carriers Act. Huh? There were two cases they cited, division bench and a single bench. Both were railways carrying carrying cargo. Carrying cargo, railways can be equated with a bus, tram, truck. It can't be with a landlord letting out property. There has to be some correlation, statutory. Secondly, Lordship will see in this judgment, this is a case, Lordship, the facts. Just one paragraph. What happened here? May I tell Lordship briefly? There was a evasion of railway freight.
You're talking about this Rashmi?
Rashmi. There was an evasion of railway freight.
Yes.
Because for the depending on the end use of the goods, the railway freights were higher or lower. If the end use was for some export purpose, then it's higher. But then if it's domestic, then it's lower. Here they made a wrong declaration and they carried the goods and evaded payment of the railway freight. For evasion of payment of railway freight, the railways gave two things: give a show cause notice, and simultaneously with the show cause notice that why you would not pay, I'm suspending your services. There was no blacklisting here. Show cause and railway services suspended. The first submission that the railways doesn't have power to adjudicate and recover its past evaded railway freight was conceded by the Solicitor General. He admitted, he appeared and said, no, I concede railways has to go to a civil suit and recover its dues. It can't self-assess its dues and claim the money.
Solicitor General?
Yes, Lordship will see that the name doesn't appear, but in the body of the judgment, Lordship will find, it doesn't have a page number, page 4, page 5. The 5th page bottom.
Yes.
Where those I and II, the two issues are quoted. Just below that, there are two broad issues, which are now before us for consideration. With regard to the first issue, there is authority and the jurisdiction of the Railway Administration to undertake an adjudication proceeding for determining the alleged evasion of freight charges and the realization thereof by coercive measure without following due course of law. We find from the judgment of the learned single judge, even the learned Solicitor General appearing for Railway Administration considered that the Railway Administration did not have any power. They appeared possibly before the trial court. Power or authority of making direct recovery of evaded freight charges through coercive measures. And the appropriate course for the railway for realization of such alleged evaded freight charges would be by institution of a proceeding of civil nature in accordance with law. Such concession of the learned Solicitor General was recorded in the impugned order. In view of such concession given by the learned Solicitor General, we do not find any necessity of considering the first issue. Suffice it to say, without taking note of such concession of the learned Solicitor General, we have no hesitation to hold that since Railways Act has not empowered the Railway Authority to deter the alleged evaded freight charges by itself, the Railway Administration, in our view, cannot undertake any adjudication proceeding for determining it. Now, Lordship kindly comes to page 2 of this judgment. What is the whole case about? Page 2, second paragraph. This being the position that recovery has to be through a due course of law, second paragraph of the second page of the judgment. On 16th August 2011,
yes,
the Railways issued a demand notice, so Lordship, the 5th line of the second paragraph. By the said demand come show cause notice, the Railways claimed some rupees 132 crores towards freight charges and a further some rupees 5 some crores towards penalty. And additionally, railway services were suspended. The said demand come show cause notice is under challenge. That's the only thing. The demand by concession goes. So the so that the coercive action as a consequence of such demand naturally falls. And Lordship also comes and sees then there is the civil suit filed where the court holds that whether the money is payable is being adjudicated. Railways has filed a civil suit. And this is in a liquid state, this claim. Lordship kindly comes to There was no show cause. I mean, there was no adjudication. There was no blacklisting. There was no inquiry. There was no blacklisting. The show cause come suspension. Page numbers are not there. That's the whole difficulty. This is how it was given, and this is how it's uploaded. I don't blame them. 4th, 5th, 6th, 7th, 8th, 9th, 10th, 10th.
No,
11th,
you have paginated my copy.
They have paginated, no?
You have.
আমাকে paginate করে দিলে না কেন? আমার যখন দিলে কিনা আমাদের paginate করে দিলে পারে। Do you have an extra one? Or should page 12 possibly we have considered the plaint of the said suit. Possibly page 12. We have considered the plaint of the said suit. We find that the very foundation of the
Mr. Mitro, you're tempting him to do certain things which may make the matter more complicated.
this is I know this is legitimately he's making it difficult for us, but then this
No, he may make it more difficult for you. That's my
oh,
point.
the page number may be different.
Very well. Yes. So just tell me what
So the
what is the
suit
point?
was there was a suit pending, so the court held even otherwise it's in a liquid shape. So in aid of a claim which you cannot make, you can't take coercive action. This was the long and short. And so far as public, and so far as then it was by referring to statute, it was said that this is a common carrier. And it has been held long time back in an old judgment that a common carrier, as in railways, cannot refuse to carry somebody's goods. There also the court, after holding all this, put various restrictions, which would dehorse the statute. Lordship kindly comes to the second last or third last page of the judgment. There was no legislation that what the railways can self-adjudicate and claim. The page, second last page really, second last page, the second paragraph from bottom. This is the third paragraph really. In our view, until such lacuna in the legislation is filled up by appropriate legislation by the parliament, the interests of the railways can only be protected if you work out the following modality. So when they were allowed to use the services, we thus direct that at the time of booking each consignment for cargo of iron or for carriage of iron or from one terminal to the other by rakes, the railway administration will realize the freight rate at class 180 plus distance-based charges. That is the additional, as per para 1 of the rate circular from the consignor, and will ultimately decide the actual freight rate payable by the consignee on being satisfied about the actual end use of the iron ore to be transported under the consignment through railway rakes or wagons. Thus, if the appellant company, after receiving delivery of iron ore under the consignment on submission of the declaration regarding its domestic consumption of the iron ore at its factory as per para 3 of the said rates, can satisfy the railway authority about the end use of such iron ore as per its own declaration, the railway authority will refund the amount. So the court fully protected railways' interest. The entire full amount will have to be paid, additional amount also. But in this case, Lordship cannot protect the interest of all the other plot holders. Because if the blacklisting is set aside, they will, with impunity, start using entering the port area and taking plots, and with impunity, they will carry on business. And there will be more incidents of.
So you're saying that that sister company's cause can't be protected. That's what you're saying.
Here, they're really protecting the sister company. One person, two companies, one caught red-handed.
Yes.
Blacklisted, and simultaneously the other the company where he's also director is also blacklisted together, because from one plot they're bringing it here. They conveniently don't file a writ petition for the entity called red-handed. They come through the other face and say, I have not done any wrong. This TR Logistics has done the wrong. So this is after a court of equity, as the previous judgment that shows a court of equity. Lordship will have to see public interest also here when it's the railways case. So court of equity plus public interest. Now, Lordship, the next judgment on this point only is the other Rashmi Metallics. Is the other Rashmi Metallics judgment by Justice Bhattacharya. This Rashmi Cement. Oh, Rashmi Cement. Sorry, so sorry.
This follows the other one.
Yes. But Lordship sees paragraph 17 is very important. Paragraph 17, section, second page, section 93.
Yes.
Section 93 of the 1989 Act engrafts the concept of common carrier under the Indian Carriers Act 1865, now section 2A of the Carriage of Goods Act, Carriage by Road Act. Section 2A of the 2007 Act defines a common carrier which includes railways. They could not show that a port is not included, including railways. Thus, railways are by definition a common carrier and cannot refuse S service. But this is the point. If
No, how does it help you? It's under an act and it defines a common carrier.
And common
Here
carrier is
the-
said to include railways.
Yes,
that
yes, that's fine. But the petitioner's argument is that you are carrying on an essential service in not only common carrier. I don't remember the common carrier argument, but the petitioner's argument was that you are providing or offering essential services. Therefore, if you blacklist, then the effect, the consequence of that will be drastic on the petitioner.
The two judgments cited by them for this proposition are this one
Yes.
and the division bench. Both are common carrier cases, statutorily common carrier. And as I said, my lord, here it is not their case that their plots cannot be taken anywhere else, or that if plots can be taken, they can also render services of carrying and lifting from those other areas. And anyways, TR Logistics has not come forward to challenge. So he was only a plot holder. Torrent is only a plot holder. And there are plots all around. So we can't cater to more than 30% of the total import-export. That's inside the port premises. So the two cases which they have cited for this proposition are common carrier cases. So that's why I'm saying, firstly, I'm not a monopoly anymore. After the privatization of ports, there are a large number of private ports now, Lordship. Adani is bigger in ports than the Indian Port Authority. There's Thamra, it's a private port, right? Within 100 miles, there is Paradip, private port. There are the private ports are everywhere there. But anyway, here it is not that they are importers, exporters. That their ships are coming and we're not letting their ships berth. It is a case of somebody taking plot and rendering services of freight services. One is equipment supplier.
Yes.
To plot holders. That we don't certainly have a monopoly in plots. But what I am saying on these judgments, these are not opposite equivalents. These are opposite judgments. Their services were common carriers within statute, railways. And this is...
Mr. Mitra, is that all, or do you want to make...
Just 2-3 more judgments they have, because anyways it will spill over because my judgment they will have to deal with. So give me 5 minutes so that they can also give their...
You want to come back on some other day?
Well, after the reopening, there's matter of those two going on some.
Mr. Mukherjee?
I would be beseeching your lordship, I would be beseeching your lordship, and if your lordship keep it day after tomorrow,
Very
since
well,
your lordship,
I have no difficulty.
takes it up on 18th and
Day after
20th.
tomorrow, I don't, Wednesday?
Wednesday, my lord, it's written in the list, my lord, today.
Lordship can take this up with the...
I can put it on Wednesday, but very little chance of it being taken up on Wednesday. There are many matters already there. Yes. This matter on 20th December 2023 for learned counsel appearing for the respondent to conclude his submissions.
HON'BLE brief.
Item number 3,
Lordship, I beg to appear on behalf of the
Runka
respondent.
Sons.
Mr. Dotto, what do you propose to do? Not keep silent, I hope, in this matter. Which one?
No. If my learned friend finishes today or sometimes in
No, my question to you was whether you would continue to assist the court or not.
But in this matter, I can.
You can.
Yes, but the previous two matters where I deliberately did not enter the courtroom, possibly in the previous two matters, I shouldn't.
Previous two matters. Yes.
The one which Mr. Mitro,
Yes.
Mr. Abhijit Mitro was arguing.
And which is the other matter?
There are two matters. In the one is the blacklisting part, the other.
Yes. Very well. Yes, yes, Mr. Mishra.
My lord may kindly take, my lord. I pray my lord to take page 200.
But congratulations, Mr. Dattu. That should be in order.
I don't know how to respond. Whether it should be a congratulation or a sympathy.
While it lasts, a congratulation. Yes. Yes.
My lord may kindly take page 200, my lord.
Of the writ petition.
Of the writ petition, my lord.
Mr. Mishra, what was your point on the last day?
My lord, larger public interest and national interest I have dealt with, my lord. Now 2 letters I will only show, my lord. And I will require a day of my lord's time. A day not, my lord. Half an hour. 2 judgments, my lord, our learned senior friend has relied upon. I will distinguish those judgments. 2 judgments I have already relied, my lord. I will place one more judgment, my lord, and I will.
So you were on larger public interest.
My lord,
on
that part I
point.
have dealt with on last day. Last occasion, my lord, I have dealt with, my lord. So 2 more letters, my lord, and larger. This is also a part of the larger public interest, my lord. 2 more pages I will, my lord, refer today from the writ petition itself, my lord. So, my lord, may kindly take page 200, my lord, of the writ petition, my lord. My lord, this is letter dated 19th of December 2022, my lord. 3rd paragraph, my lord, from the top. My lord, this is the letter issued by the petitioners to us, my lord. We, vide our letter dated 5th of September 2022, specifically dissent with your proposal towards according our consent to the railways for use of the rakes by the railways to load the same for other party. In the said letter, my lord, this is very important. We expressly apprised you to stable our all GPWIS rakes, my lord.
Yes.
Now, my lord, last paragraph
Just
of the
1 minute.
my lord.
Screen to change color.
Oh.
Yes.
Now, my lord, last paragraph of the same letter, my lord. Therefore, we decline to accept any offer or for rebate as proposed due to unauthorizedly and unilaterally used of our GPWIS rakes by the railways. For the time being, as you are still continuing with such unilateral and unauthorized acts in the contravention of the agreement dated such and such executed with Southeastern Railway, my lord. Now, my lord, kindly takes our reply. This is 27th of December 2022, appearing at page 203, my lord.
20?
Page 203. 27th of December 2022, our reply,
Yes.
my lord.
Yes.
There is one more reply, sorry, my lord, I stand corrected. 202, 21st of December. Subsequently, my lord, 21st of December 2022, at page 202 of the writ petition, my lord. Now, my lord, this is the reply given by us on 20. Your representation has been examined and it is felt that the matter would have been better appreciated if communication made with the opening branch of issuer for subsequent loading has been provided. However, based on your appeal, this office has already requested Chief Freight Transportation Manager East Coast Rail to move your GPI in consonance with the railways. Railway board has also been informed to the same. In this connection, you are also requested to closely coordinate with the operating branches of the zonal railways for timely intimation of the subsequent loading to ensure proper movement of your GPI in return direction. Now, my lord, our reply again at page 203, my lord.
Yes.
Now, my lord, we have given the explanation, my lord, to the letter, my lord. Paragraph 3 and 4 are important, my lord. My lord, therefore, these rakes were loaded to HSPG with cargo of certain other party, as no railway-owned rakes were available on that day. CP is situated at a distance of 31 km from HSPG in the empty direction. Railway has handed over the rake through RBS route in approved empty direction as per GPWI's policy. So, my lord, in a whole, my lord, time and again the petitioner wanted to stable the rake, my lord. And it is on record, my lord, that there were no rakes available with the railways during that period of time. Now, my lord, stabling of rakes, my lord. This is not only the petitioner.
But during the relevant period of time means what?
My lord, particularly July to November, my lord, on last occasion I have shown, my lord. There was a shortage of powerhouse coals during all the resources was utilized to supply the.
So you wanted to use their rakes?
My lord, during that period it has been used. July to November, not only the petitioner, other operators who are within this scheme, my lord, GPWS, all other empty rakes were used.
Yes.
My lord, the condition is that when they have no indent available, if they have loading for their rakes, we will never use them, my lord. Only when they have no indent, they want us to stable the rakes. Now, my lord, stabling of rakes, my lord, if every single rake or private rakes that are being asked by the system to be stable, my lord. Now, my lord, the stabilization of the rake will entirely disrupt the entire system, my lord. Be it freight or be it passenger traffic, my lord. Last occasion, my learned friend has been kind enough to appraise the court, assist the court about the, my lord, size 66 wagons in one rake, my lord. So, my lord, stabling these rakes, my lord, on a whole will disrupt the entire freight movement as well as the transport passenger movement of trains, my lord, in the zone. So, my lord, and second point, my lord, railway were running short of rakes, my lord. So, my lord, in larger interest, my lord, to cater the need, my lord, because it is not only that railway is generating, my lord, even today, my lord, if you say on a general, that passenger freight is 47% subsidized, my lord. So keep the things going, my lord. It is very important that rake should be operational, my lord. Stabling this will create a problem, my lord. And it is a very freight sensitive zone, my lord. Highly freight sensitive zone, my lord. On last occasion, I have shown from the letter itself, my lord. My lord, all these decisions, my lord, I humbly submit, all the decisions, my lord, which have been made by the respondents, my lord, by the railway authorities, my lord, they have been bona fide and with best intention, my lord. There was no malafide intention behind these decisions, my lord. Keeping in view the larger perspective, my lord. Thrice amendments were made, my lord, throughout this policy, my lord. 2 favoring the petitioners, my lord, which they don't object, my lord. Initially, this project was that the end user, the GPWIS rakes they own, they will only be allowed to use in a particular direction. Keeping in view the economic feasibility of the rakes, my lord, they were allowed to give them to third party through other users who will use their rakes, my lord. So overall, we also keep view that their money is being invested, they should get the return. So this is not a case. Whenever they want to stable, this will be the create the problem, my lord. In this regard, my lord, one more judgment I will rely upon, my lord. This is Arun Kumar Agarwal versus Union of India and others. Reported in 2013, volume 7, Supreme Court Cases, volume 1.
On which point?
My lord, this is the financial issues, my lord. These are
financial
issues of the state, my lord. This runs on trial and error method, my lord. Relevant paragraphs is, my lord, 40 to 49, my lord. And
40 to 49.
40 to 49, my lord. Internal page 17 to.
So what, this is also in aid of the public interest argument?
My lord, public interest and financial policy of the state, my lord. That in view of a public financial policy of the state can change, my lord. And my lord, conclusion of the court is at page 53 of paragraph 53. Sorry, my lord. Paragraph 53 of the said judgment, my lord. So, my lord, my lord, I have relied upon my lord's judgment, my lord, in Kolkata Municipal, Kolkata Metropolitan Development Authorities case, my lord. Second one judgment that I have relied upon is Yamuna Expressway, my lord, reported in 2022 SEC Online, Supreme Court 655, my lord. And this is the third judgment, my lord. Now, my learned senior friend has relied upon MP power. MP power, my lord, para 75, my lord. KMD is unreported. I mean, copy my lord. So, on factual aspect, my lord, the crux of the matter stands at, my lord.
Yes.
My lord, 18, this policy was promulgated, my lord, formulated, it came into existence. Now, my lord, first amendment came in June 20, two amendments.
Amendment to what?
Three amendments were done. Overall, as of now, 3 amendments were made in this policy, my lord.
Yes.
3 amendments time to time with the changing circumstances, freight movement, economic sustainability of this entire scheme, my lord. The policies were time to time changed, my lord. Now, my lord, my first bone of contention, my lord, most humbly I submit, my lord, this is even, my lord, the railway being a state, this is a private dispute between the parties, my lord, being not amenable to writ jurisdiction of the Honorable Court, my lord, number one. Number two, my lord, all the decisions were taken bona fide in larger public interest, my lord. Number three, my lord, these not so arbitrariness was not there, my lord. I have shown on the last occasion, my lord, their interest is fully protected under this scheme, my lord. It is the petitioners who has refused, my lord. Page 202 and 203 I have shown, my lord. So, my lord, these are my humble submission. I will need 15 minutes of my lord's time on any given date, my lord. I will distinguish the judgments which have been relied upon, my lord.
Why do you want to do it now?
My lord, I am not prepared on the judgments, my lord. Anyhow, my lord, that I missed, my lord. I am really sorry for that. Any day, my lord, 15 minutes of my lord's time, my
So
lord.
that has to be then in January.
My lord.
Yes, Mr. Dotto and Mr. Yes, give me a date in January, please.
Subject to such convenient time.
First week, my lord, any day?
First week. It has to be a Wednesday. It has to be a Monday.
My lord.
So 9th. So 9th. 8th. Learned counsel appearing for the respondent railways has made his submissions but seeks to distinguish the decisions shown on behalf of the petitioner. Stop. List this matter on 8th January 2024 as prayed for.
I'm grateful.
Grateful, my lord.
Call on the next matter.
Item number 4.
Let I appear for the petition.
Item number 4 and 5.
I am only to give reply to the submissions which were concluded on behalf of the state by the learned Advocate General. But this is regarding that, my lord.
Yes, sir.
The stamp that is required for the transfer, whether
Mr. Chaudhary, is there any decision in the last 3 weeks on this issue?
decision last 3 weeks, my lord. To be very honest, my lord, I did not check last 3 weeks, my lord, but since it's falling from your lordship, I'll check it up.
No, generally I try to keep myself updated, but
I haven't come across, but my lord, I'll check it up.
there was one decision which I was going through, and not the entirety. I did not get the time, but I suddenly remembered of this matter. So just anyway,
I'll check it up. I'll check it up.
you check it up and you make your submissions now.
But essentially, my lord, 8 points have been made on behalf of the state. Number one, my lord, the first point was that the property in question, my lord, shall I just in 2 minutes recapitulate what I had argued before, my lord, dealing with that? We come back to your lordship. There was a declaration scheme of 2005. Under the scheme, my lord, certain concessions were given that if declaration is made within a cut-off date, then the declarant will get certain benefits. One of the benefits was that if the real owner declares the income by which he had purchased a property in the name of the benamdar, and that declaration is made within the particular period, and the property is transferred within the particular period, then that property will be outside the rigors of the Benami Transaction Prohibition Act. This was the benefit that was given in the declaration. Now the petitioners utilized that benefit, and my lord, there is no dispute that declaration was duly made under the scheme, and the property was to be transferred. The cut-off date for there were two cut-off dates.
Yes.
The declaration was to be made. The scheme was operational from June 2016 till 30th of September 2016.
Yes.
So the declaration had to be made by 30th of September 2016.
Yes.
And if you have made the declaration by 30th of September 2016, the property had to be actually, my lord, transferred by 30th of September 2017. 1 year grace period was given.
Transferred to the real owner.
Real owner. Now, my lord, this is when, my lord, when we put in the deed, my lord, the instrument of conveyance was, my lord, titled as deed of release. And it is at that stage when it was presented, my lord, the state put up an objection that this instrument is to be stamped and valued as not as a release deed, but as a conveyance.
Yes.
And it is at that stage, my lord, we filed the writ petition. Pursuant to an interim order, my lord, the document was registered because the cut-off date was there. And my lord, we were asked to put in the amount. From an ad interim order, it had gone right up to the appeal court. We were asked to put in the the differential amount of around 1 crore and odd, which has been deposited by the petitioner before the registrar. So, my lord, that money is lying secured. And now, my lord, the question is, how should the document be stamped? Now, my lord, my initial opening arguments was that if the declaration comes into effect and the rigors of the Benami Act does not apply, then the law as it stood prior to the Benami Act 1988 coming into force, that would apply. And the law was that real owner always had the right. So there was no fetter, no embargo, therefore it should be only treated as a deed of release. And my lord, I had cited 3 judgments, 2 of the Madras High Court and 1 of our full bench of our Calcutta High Court and 1 Bombay High Court, 4 judgments.
Yes.
Now, and I had also shown that if the idea of the state is that it should earn more revenue, then it is required that the Stamp Act should be amended, and the portion where, my lord, the duty is charged, that should be made at par with conveyance. Because even today, my lord, as far as the West Bengal amendments are concerned to the Indian Stamp Act, release is, my lord, a much lesser fee than, my lord, conveyance, which is, my lord, 6% or 7% of the property value. And I had shown to your lordship the corresponding amendment with which Tamil Nadu legislatures made after the 2 Madras judgments. They, my lord, made it at par with the conveyance because, my lord, release also, it was, the stamp duty was, my lord, made a certain percentage of the value of the property.
Yes.
Now, in reply to this, the submissions made by the then Advocate General was, first was that the property was purchased in 2004 when the 1988 Act was in operation. Therefore, 1988 Act applies and that situation has not changed. This was his first submission.
Yes.
The second submission was that this is not a case of transfer, but a case of perfection of title. And apropos this, my lord, he distinguished the cases which I had cited, that all the cases cited, the Madras, the Bombay, all were dealing with a situation prior to 1988 Act. And therefore, my lord, it was submitted that it would not apply. And my lord, fourthly, it was submitted that in 2004, since no title could remain with the real owner, that is the person who paid the consideration, it's not a question of release, it has to be a question of transfer. And to buttress that, my lord, he further submitted that the Act, it applies to the declaration and not to the declarant. This was one of the submissions made, that this waiver scheme, Income Tax Waiver Act, my lord, applies to the declaration and not to the declarant. And once a declaration is made, then, my lord, attention was drawn to Section 6 of the Act, which was amended. Section 6 now makes a retransfer, my lord, violation of law. Retransfer is prohibited, and it has introduced penal consequences if anybody tries to retransfer. So it was submitted that Section 6, you are getting the benefit of Section 6 once you make the declaration. These were the submissions made. And lastly, my lord, one Supreme Court judgment was cited where a portion of the finding of the full bench decision of Calcutta High Court was overruled. So in that sense, it was submitted that as if the decision has been overruled. But that is perhaps not correct. I'll come to that. Now, my lord, my answers to this are as follows. My lord, I do not join issue that the Act applies to the declaration and not to the declarant. I concede to this. Yes. But what is the effect once you make the declaration? The effect is that the 88 Act ceases to apply. The 88 Act ceases to apply to the transaction which is the subject matter of the declaration. And once that happens, that transaction takes place as if the Benami Transaction Prohibition Act is no longer there. And, my lord, this will be further, my lord, established from the fact that Section 6, which was shown by Mr. Mukherjee, Section 6 was amended and introduced with effect from 1st November 2016. That comes into force on 1st November 2016. But the cutoff date, so far as the scheme is concerned, is 30th September 2016. So, my lord, taking the argument advanced logically, till 30th or 31st of October 2016, any real owner could have sought a retransfer from the Benamdar. There was no prohibition. It is not that you have to make a declaration. Even without making a declaration, if somebody pays full conveyance, my lord, they can retransfer. So, my lord, that is where the fallacy of that argument is. Section 6 was introduced from 1st of November 2016. That is, my lord, after the cutoff date of 30th September, my lord, there was a 30 or 31 days sort of a hiatus, and after that, my lord, Section 6 was introduced. My lord, second submission is, Lord, if Lordship takes us, my lord, this is with regard to, it is a case of transfer and not a case of, but a case of perfection. Apropos that, Lord, the transfer language is used in Section 190. If Lordship takes that section 190, that is where it uses that section. Lordship can take the written notes also, my lord, he'll come back, where I have set out the provision. Written notes, my lord, second page, Lordship will find 14th May.
Yes.
In the list of dates, Lordship will find, and towards the bottom, 190, undisclosed income not to be treated as Benami transaction in certain cases. The provisions of Benami Transaction Prohibition Act shall not apply in respect of the declaration of undisclosed income made in the form of an investment in asset if the asset existing in the name of the Benamidar is transferred to the declarant. Well, this transferred expression was relied upon by Mr. Mukherjee to contend that this has to be construed as a transfer, and only after a transfer is made, then this will not apply. The first part will not apply. My lord, I join issue over there, and I would just read it once again. Kindly see. The provision of Benami Transaction Prohibition Act shall not apply in respect of the declaration. My lord, I am stopping here for a moment. So once I make the declaration, the act is not applied. But if I just break the sentence in two parts, the provisions of Benami Transaction Prohibition Act shall not apply in respect of the declaration of undisclosed income made in. So, my lord, once the declaration takes place and the cutoff date is 30th September, the provision cease to apply. So, at that point of time, this section 6, the present form of section 6 was not applicable. Once I make the declaration, there is no prohibition so far as the regards of the act is concerned, my lord, it does not apply, and my lord, I can transfer.
No, so declaration, when you're saying that once you make the declaration, then rigors of the 1988
doesn't
Act,
apply.
yes, will not apply.
And as a logical consequence, if the act doesn't apply, then the position in law as it was prior to 1988 automatically comes into effect. That is why the judgments which I have cited, which is all dealing with the law prior to 1988, my lord, is enforced.
So then why do you want, so this sentence you want to break up to investment in any
Yes,
asset?
because, my lord, it was the submission of Mr. Mukherjee that, my lord, the second portion, that is in the form of investment in any asset, if asset existing in the name of Benamidar is transferred to the declarant. So, his contention is that when it is being transferred to the declarant,
yes,
then the act will not apply. And that has been facilitated by the amended section 6 introduced on 1st of November. That was his contention.
Yes.
I am joining issue to say that no, section 6 has come into effect only on and from 1st of November 2016.
Yes.
The cutoff date of the declaration is 30th September 2016. It was perfectly possible for me to get a transfer done even in October. I have a time for 1 year from 1st of October till October 2017. But I could have easily done it before if, my lord, things were otherwise there. My lord, there was no issue with regard to stamp in 1 day. Theoretically, my lord, the registrar accepts it, a deed can be done. So there was no bar really. Even as on October, there was no bar in making the transaction because 88 Act will not apply. And this act not applying is not for an unlimited period. It is for the period till October 2017, by which time I have to get the deed or
why October?
Well, at 1 year time, 30th.
1 year.
I'm sorry, Malad, 30th September 2017. I made a mistake. 30th September. 30th September 2016 was the cutoff date of declaration.
Yes.
Until 30th September 2017, I had to, Malad, put in the, make the transfer, or the instrument has to be executed. Well, this being the position,
yes,
my respectful submission is kindly concentrate on the first limb that shall not apply in respect of the declaration. So once a declaration is there, 88 Act is 88 Act does not apply. And the fact that transaction had happened in 2004, it does not matter. It is exactly that which is being cured. In 2016, this is being cured. And well, the second part of it, if asset existing in the name of Benamidar is transferred to the declarant, this transfer, my lord, can be in any of the modes recognized by law. The fact that the expression transfer has been made does not necessarily mean conveyance. It can also be a release. It can also be other modes of transfer like gift or otherwise.
So if the sentence is not broken up, then would that give any advantage to the respondent?
Well, if the sentence is not broken up, well, it all the more, my lord, corroborates the stand that the petitioner is taking. I read it up, my lord, without pausing. Provisions of Benami Transaction Act shall not apply in respect of the declaration of undisclosed income made in the form of investment if the asset in the name of the Benamidar is transferred. Well, the declaration is in the respect of the income.
Yes.
And this income is, my lord, in relation to the asset. Because, my lord, in this scheme, there were other benefits also given. We are not concerned with that. We are only concerned with the income which is disclosed for buying the asset in the name of the Benamdar. Once that income is disclosed that I have, actually it is my 1 crore rupees which I had spent to purchase the property in the name of X. Once I give the declaration, I have to make it, I have to do it within 1 year. This income as the my learned junior rightly points out, if we read it again, the income, kindly see the last two lines, declaration of the undisclosed income made in the form of investment in any asset. So, the second limb is really linking the income to the asset. That's all. And the only next cutoff date is this entire documentation has to be done by September 2017. Income made in the form of investment in any asset, if the asset existing in the name of Benamdar is transferred to the declarant, being the person. So, that is why, I am also not joining issue that the it applies to the declarant, it applies to the declaration and not to the declarant. Because once the declaration is done, 88 Act or the rigors thereof goes away.
Yes.
And another fallacy of the argument of the state is that it is reading the expression transferred to mean only conveyance or sale. That is another fallacy. Now, in this context, my lord, the only judgment which was, the first judgment which was cited on behalf of the state was of Justice Bachawat, my lord, AIR 1967 Supreme Court. The real intention, my lord, that judgment, Lordship would recall, was already considered by the Bombay High Court.
Yes.
That page 7 of my note, if Lordship comes
Yes,
to.
yes, I remember this.
1990 Bombay, while construing that, has already considered that judgment, and this distinction is also there in my note. The Lordship will find that. I'll just give you a Lordship. Bombay High Court has already considered that. There is 67 Supreme Court essentially says that the document in question has to be read as a whole to call out the real intention of the parties, and that really doesn't alter the situation, or is not opposed to the contentions which I am raising. Now, so far as the two Madras decisions are concerned, it was submitted that now by virtue of the Benami Transfer of Prohibition Act, the erstwhile provision of the Indian Trust Act, that was repealed. So therefore, these provisions will not apply. The erstwhile provisions of the Indian Trust Act, section 56, was repealed by the Benami Transaction Act. That once the act goes, section 56 of the Trust Act automatically comes into force. That is, section 81 and 82 of the Trust Act. Benamidar holds the property in trust for the real owner.
Yes.
That automatically comes into force. So, that submission also does not, really counter to what I said.
This is his, this was the second or the third submission? The one you said
this was trying to, the two Madras judgments which I cited.
Yes.
All the citations where, the property was in the name of the wife, the money was paid by the husband. So, vis-a-vis the then provisions of the Indian Trust Act, that is prior to 88, when those provisions were not repealed, it was entitled that the wife was holding the property in trust for the husband. In that line, these were all upheld.
Yes.
And a deed of release was held to be a perfect instrument. Now, to distinguish that, the submission made was that once the 88 Act comes into force, you cannot have these sort of transactions because those two provisions of Trust Act has been repealed by the Act of 1988. That was the submission. Section 7 of the 88 Act says Section 81, 82 and 84 of Indian Trust Act and 66 of Income Tax Act, Code of Civil Procedure and 281 of Income Tax Act are repealed. This is what Section 7 says. But once this act of this declaration scheme comes into effect or this act comes into effect and 88 Act does not apply, the automatic corollary of that is, my lord, this also goes. The entire embargo of this goes. But we are not concerned over here because this is not a husband-wife situation. But whether, my lord, this analogy that the Benamdar is holding the property in trust for the real owner can apply in this case. It is only for that situation, my lord, we had cited these judgments. The last case which was cited was 1996 7 SCC.
Just 1 minute, Mr. Chaudhary. You mentioned something about some fallacious construction done by Mr. Mukherjee. That also pertains to page 5 of your note. Not 5.
Well,
page 3. Page 3 of your note.
Yes. Well, there were twofold contentions made by Mr. Mukherjee. One was interpreting Section 190,
yes,
where, my lord, he tried to concentrate on the expression transfer, and he says only when the transfer takes place, this act will not apply, not prior thereto.
Yes.
This was one of his arguments. To that, and for effecting the transfer, a document or an instrument has to first come into force, then only it will come into effect, otherwise not. To that, I said that no, his first submission is the fallacy I pointed out, that he also admits it applies to the declaration.
Yes.
And, my lord, I concentrated on the first half, as I did today, that if you concentrate on the first limb of Section 190, that it shall not apply in respect of the declaration of undisclosed income, then moment the declaration comes, the act ceases to apply. And the second aspect was, my lord, with regard to the application of Section 81 and 82 of the Trust Act. I said that 81 and 82, once 88 the 1988 Act, my lord, is removed or the regards do not apply, then, my lord, even so far as Indian Trust Act is concerned, my lord, Section 81, 82 and all the provisions which were repealed, my lord, they also go away. And, my lord, in effect, in law, it has to be presumed that, my lord, those are existing so far as construing, my lord, the relationship vis-a-vis a real owner and a Benamdar is concerned. That is, the Benamdar will always be deemed to be holding the property in trust for the real owner. And that was the position of law prior to 1988, as has been, my lord, construed by the Madras High Court, Bombay High Court, and so on.
Mr. Chaudhary, you continue with your submissions, but this argument which has been going on for a while, what is the factual context to it? That something must have happened to you because you after which you came to court.
Or entire factual context is, my lord, the document should be stamped or, my lord, should be valued as an instrument of release or an instrument.
No, there was a demand made on you and which you refused or something.
No, when we presented that document, my lord, the document is titled as a deed of release.
Yes.
When we presented the document before the registering authority for stamping, the stamping authorities, the collector said this has to be valued as a conveyance and not as a release. That is where the
Very well. It was at that point of time that
point of time, my lord, we came to this honorable court. There was an interim order of Justice Somapti Chatterjee which allowed that you accept the document as a release with the fee payable on release. And, my lord, later on the balance amount was at that time only the disputed amount was directed to be deposited with the registrar. So far as, well, if the state,
yes, so that is page 2 of your note.
Yes.
All these facts.
Yes.
Yes.
Well, a prima facie finding is there by this honorable court in the order of Justice Somapti Chatterjee that, my lord, this should be a deed of release. On that prima facie finding, my lord, the authorities were directed to get the document registered. But after registration, the document was not being returned to me. At that point of time, my lord, we made an application and the state said, no, our contention, it is a conveyance. And my lord, there was an order passed by His Lordship Justice Shogato Bhattacharya that you put in the money, balance amount, and we had put in the balance. We had preferred an appeal. Appellate court directed, my lord, that that the writ petition itself should be heard out expeditiously. My lord, the Advocate General agreed to that. And my
So
lord,
you have not referred to Justice Chatterjee's order here?
my lord, it is there, my lord. Page 6.
6.
25th September
Yes, yes.
2017. What is not referred to here is after 30th of September 2017 filing of the writ petition, there was an application in which, my lord, an order was passed. That is only a procedural in nature because now Lordship is hearing on the writ petition on merits. The money is lying there, my lord. If the state is successful and my writ petition is dismissed, my lord, state will get the money which is lying deposited. If I am successful, my lord, I will be entitled to withdraw the money which is lying there. This is the factual context in, my lord, the entire argument is being made.
And your prayers,
The prayers in my writ petition, Lordship will kindly take the writ petition.
26380 and 263.
Anyone will do, my lord. Lordship is hearing.
So two instances of rejection.
Two deeds, two different petitioners, therefore two different writ petitions.
26376. ওইটাই 26376.
My lord, kindly see prayer B at page. This should be 14. Oh, 10.
Yes, I have it.
Writ of in the nature of mandamus directing the respondent registering authorities to execute and register the deed of release forthwith by in any way before 30th September as per e-assessment slip being query number so and so. But this e-assessment slip and query was raised in the context of a release.
Yes.
But now an additional, because this has been done by the order of Justice Chatterjee. The release, the document itself is now lying with the authorities. If we are successful, they are to return the document to me as a release without insisting for payment of any extra stamp duty. And if, we are not successful in this, then, the money will go, which is lying with the registrar, will go there, and, they will stamp it as a conveyance and will release the document. The document has to be released. But, this prayer C is important. That, so far as this document is concerned, this declaration that asking of fees as a conveyance, if, Lordship is with us, so far as the contention.
Just 1 minute, Mr. Chaudhary. What is this e-assessment slip dated 23rd September? Just give me the page number, please. P3. I'm looking at the prayers in the.
Yes, ma'am. P3 is page 41. The e-assessment slip is that now with the internet, now they have the website.
Once you put in the property details and you put in the document you want assessment being done, since the circle rates are there, they value the upon the area of land, they value the market value, the stamp duty, and that is the assessment. Yes, so page 41 is your bone of contention. Page 41 is the slip with which we had valued. Lordship will find at page 41. So this is your valuation.
My valuation as obtained from the e-assessment slip. Lordship will find Article 55 written on the top. Ninth row from the top. There is query number here, query date, applicant name, transaction. Then kindly see under transaction, there is a computer number 0805 release without consideration value. Then set forth value is given and then total stamp duty payable, then 50, rupees 50, article 55. And will at the bone of contention that Lordship is asking, Lordship will come to page 27, which is the document in question. 27th.
Yes.
Lordship will find the document is typed as a deed of release and it has all the essential elements of release. But at the top, Lordship will find when we had moved the writ petition and the authorities had refused registration, stamp duty of conveyance is required. As the document is not duly stamped, the presentation of this document is refused. So, this was what was sought to be corrected, and the document has now been presented within the time and registration has taken place. The only outstanding issue is whether the stamp payable will be as per conveyance or as per release. That's all.
Yes. So the other prayers are just for declaration and
Yes, yes. But only thing Lordship will make a note that now the registration has been done with is over because of the order of Justice Chatterjee. We have to get our documents back.
so G is no longer relevant.
No longer relevant because of the order of Justice Chatterjee.
Justice Chatterjee ordered to
That yes.
Must be in the records.
But we had also given it. It is there. And I think there is a supplementary. সাপ্লিমেন্টারি নেই, আলাদা করে দেওয়া আছে দেখো। দেওয়া আছে, জজ সাহেব দেখেছেন। হ্যাঁ, আমাদের ইন্টারলকুটরি অ্যাপ্লিকেশনের কপিটা আছে, একটা জিএ নাকি হয়েছিল তাতেও দেওয়া আছে, একটা আইএ ছিল না তাতেও দেওয়া আছে। কপি আছে তোমাদের?
No, if it's part of some application, then let me know, then I will find it.
3676.
Scan 1, page 15. Yes, considering whatever.
Yes.
Page 17.
Lordship will see internal page 2 of the order. Article 55 was quoted. So this is the provision of the statute so far as schedule, my lord, applicable in West Bengal is concerned regarding the deed of release. And my lord, I had cited the corresponding Article 55 vis-a-vis the Madras legislature. They have amended it and it is no longer a fixed fee. It is no longer 50 rupees. They have, my lord, made it a percentage of the value, linked it with the valuation of the property.
So there was a kind of a prima facie satisfaction.
Prima facie finding, and my lord, it was done, but the documents were not being released to us. After that, my lord, we had taken out an application, and there is another order of Justice Shogoto Bhattacharya, which, my lord, should be order dated 24th February 2022. When, my lord, this order directed the additional court directed not to release the deeds till it is heard by the court. And my lord, the deposit, the fact is that 1 crore.
Which learned judge was that? The
Well,
Justice Shogoto Bhattacharya.
Shogoto Bhattacharya. 24th February 2022, that was in Can 1 of 2020.
That's also part of the same application.
This was in that application only Justice Chatterjee's order was annexed, in which this order was.
No, that order, Justice Bhattacharya's order, is not part of Can 1.
No. In that, my lord, in Can 1, Justice Shogoto Bhattacharya.
Yes.
And against that, we had preferred an appeal in which, my lord, it was agreed that, my lord, this writ would be heard of expeditiously, and we came to your lordship.
And Mr. Chaudhary, have you given these facts somewhere? Because the judgment can't be only
in the written notes, all the facts leading to the writ petition and the arguments and argument of state and our response, everything has been given. Only thing that is missing is this Can part. Can part has not been referred to because, my lord, it was really, my lord, only hearing of the writ petition, nothing transpired vis-a-vis, my lord, the Can order and, my lord, the appeal, because, my lord, we agreed before the appellate court that since the hearing is...
Yes, so you stop at 30th September 2017.
30th September.
After that, there is a Can, which you filed.
In which an order dated 24th February 2022 was passed, where, my lord, the Can was because the authorities were not releasing the deeds. So, my lord, that Can was dismissed, saying that the authorities are entitled to keep it. Against that, my lord, till the writ is being disposed of. So, we preferred an appeal. In that, my lord, we had agreed that this would be on merits. Since, my lord, it's only a question of law, on merits this can be disposed of. So, factual context is only how this document is to be stamped. And, my lord, in law, the contention is what should be the construction of section 190 as to whether a transfer from a benamdar to the real owner is to be treated as a conveyance or a release. And the two, my lord, conflicting propositions are, my lord, I have submitted, and it is the case of the petitioner, that once the rigours of 1988 Act goes away, the real owner who always had title and the benamdar was holding it as only a trustee. So, my lord, when the benamdar is declaring the property in favor of the real owner, it satisfies the conditions of a document of release. It's only perfecting my title, which I always had, because the 1988 rigours are removed. And the contention of the state is that because it is a 2004 transaction, you never really had the title, and only this declaration is facilitating you in getting the title. Therefore, it should be a transfer or a conveyance. These are the two rival contentions.
And no, you have distinguished the decisions and all that.
Yes, Malad, I have already done it. But only one decision is left. That is the Supreme Court judgment, Malad, that is of 1996, Volume 7, which overrules a portion of, Malad, the Calcutta Full Bench. Malad, quickly, Lordship will see. Malad, that doesn't alter the situation. Calcutta Full Bench had construed the deed of release. The construction of the deed of release remains the same.
Yes.
Calcutta Full Bench relied on the deed of release, and, my lord, it held that because 1988 Act has retrospective effect, because that point of time Mithilesh Kumari was ruling the field, because it had retrospective effect, so the Calcutta Full Bench held that the person did not have any authority to execute a deed of release. Therefore, the conveyance which was made in the release made in favor of the partnership firm did not get any title. The Supreme Court, my lord, only alters this fact and said, no, this is incorrect. That point of time, the Act did not apply, because by that time, my lord, Mithilesh Kumari had gone. It did not apply. The deed of release was perfectly valid. Therefore, the partnership firm had the title and not the person in... Surendra Kumar is the name, not the person in question. That's all. In fact, my lord, if I read one paragraph from the Supreme Court...
Mr. Chaudhary, no, not
very well.
In any case, today, for some reason or the other, your submissions had a very lullaby effect on.
No, then it's not a good day to continue. I'll come back.
No, no, you don't have to come back. You, because I don't want to waste the holidays. You just,
But the notes cover everything, my lord. In case lordship has any lordship will any queries, my lord, lordship can keep it as to be mentioned. In case my lord has it, otherwise my lord concludes the hearing.
no, no, I want to conclude the hearing
Yes.
because, again, I don't want to keep it beyond the vacation.
Well, the notes cover everything. The only additional point it doesn't is, my lord, because, my lord, in the second round, my lord, this case was cited to contend that the Calcutta decision has been overruled. That is only a portion of the judgment, my lord. That portion has only been.
Yes, you do something, Mr. Chaudhary. Just like a half page on this Shankarahalli judgment.
Very good. Very good.
Just a half page on that.
Very good.
This 1996 7 SCC.
Yes.
Just a half page on that. What you just said, just a half page. Nobody is appearing for the state. Mr. Mukherjee did not have any juniors in the matter.
Mr. Topon Mukherjee, senior advocate, was assisting Mr. Mukherjee
Yes.
at that point of time. In fact, I had a talk with Mr. Dokto also that he said, no, I am not looking after. But I don't know.
No, no, I'm not what?
But here, Mr. Dokto is not aware of this matter, but somebody on behalf of junior advocate on behalf of the state must be there. But I'll find out from Mr. Mukherjee, Topon Mukherjee, my lord, whether he's still there. He should be there.
At least you should allow them to be happy with some transitions. Yes, learned counsel opinion for the petitioner has concluded his submissions. Counsel is requested to hand up clarification on the decision shown by the state, by the learned advocate general appearing for the state, namely, just citation there, 1996 7
1996 7 SCC, page 55.
Give it Mr. Chaudhary by Friday.
Very well.
Yes, I don't want to keep the matter because I can't in any it's only on Mondays. এটা কি শুক্রবার দিন রাখা যাবে? শুক্রবার দিন রাখতে চাই না, বুধবার।
But by Wednesday, I shall file.
Yes, I don't want to keep it on Friday.
Lordship will keep it on Wednesday. I shall give that.
Yes, list this matter on 20th December 2023.
There are